Really over to you how you want to do your initial presentation. Are you going to be asking your experts to also give a presentation at this point?
I haven't specifically asked my experts to prepare a summary. My intention is to provide a summary for the quarry zone first in terms of to the hearings panel, and then do the open space zones later and provide you in the interim a chance to question the...
Okay, all right, that's fine. Thank you for that. We have some pre-circulated a statement from you. I don't know whether the people in the back have that as well, but we could certainly make that available. We haven't seen it. It's the first time we've seen this as well. So over to you, Mr. Bellamy.
I'll read through my summary statement, but there'll be parts where I won't go verbatim because I don't think you need to have all the everything listed out with a list. So
thank you. I'm just wondering, can you bring the microphone a little bit closer and try to speak up?
How's that?
Oh, that's really good now.
Okay.
Thank you.
My name is Sean Bellamy. I'm an intermediate planner of Hutt City Council's plan review team. I prepared the Section 32 assessment and the Section 42A assessment reports for the open space inquiry zones and the rebuttal statement. I understand that my evidence can be taken as read. To assist the hearing panels, I'll briefly outline the planning framework for activities in the quarry zone and the sensitive activities in the quarry protection zone, protection overlay in the general rural and rural lifestyle chapters. The overview of the quarrying zone and sensitive activities within the quarry zone protection overlay. The quarry zone is characterised by quarrying activities and a mix of ancillary activities that use the aggregate quarried from the site. The quarry zone provides for quarrying activities and ancillary activities. District Plan seeks to manage the effects of quarrying on adjacent zones through a quarry management plan, standards, managing the heights of structures, visual buffers, hours of operation and vibration. Residential units, residential activities of visitor accommodation in the nearby rural areas are identified as potentially increasing reverse sensitivity to quarrying activities in the quarry zone, and a resource consent pathway is required for these activities within the quarry zone protection overlay. Submissions on district-wide issues such as noise, transport, earthworks, natural hazards and light will be heard in the relevant later hearing streams. So before I go on and go into the assessment proper summary, there is an issue related to a concurrent application for a land exchange and fast-track application for resource consent. This is concurrent to the proposed district plan and plan change. Winston Aggregates is seeking a land exchange with the Belmont Regional Park with the intent of expanding their operations into this area. To date, this process has not been completed. There is an associated fast-track consent, resource consent process. My understanding at the moment that that hasn't been applied for as yet completed, so it's still in the pre-application process. Winston Aggregates Limited has made extensive submissions relating to the provisions of the quarry zone. There are a number of provisions that I've listed down there. I won't go into them in detail. Suffice to say that the key points related to conservation activities, vibration, visual amenity were the key points that came up, as well as the quarry zone protection overlay. In preparing my evidence, I have reviewed the relevant submissions and further submissions and the evidence filed by submitters. I generally continue to support the recommendations contained in my Section 42A report in relation to the matters allocated to me. The focus of my rebuttal evidence is on responding to the submitted evidence and identifying whether any refinements to the recommended provisions are warranted. In making these recommendations, I'm reliant on the peer reviews of the technical evidence that was supplied by Winston Aggregates, specifically reviews from Malcolm Hunt for noise and vibration, and Rose Armstrong for landscape and visual amenity. In general terms, I continue to support the direction of the Quarry Zone chapter and the Quarry Zone protection overlay in the general rural and rural lifestyle zones, and consider it provides an appropriate framework for managing quarry activities within the Quarry Zone, managing the adverse effects of quarry activities on adjacent zones, and managing the reverse sensitivity of sensitive activities on quarry activities in the Quarry Zone. There are the principal matters where I've recommended amendments to the rebuttal I've listed down below, but they generally relate to vibration, some provision, reworking provisions that relate to visual amenity, and a suggested change to the rule for sensitive activities in the Quarry Zone protection overlay. Other than those matters, I generally support the recommendations contained within the Section 42A report and the associated recommended provisions. I note that additional evidence was provided for the hearing today by Winston Aggregates, and that was received late on Friday. I have had an opportunity to read it, but at this stage I don't feel confident, or I don't feel I can provide the panel with an assessment of that and a recommendation. I would like to provide that as in the right of reply at the end of the hearing. And that is, I'm happy to answer any questions from the hearing panel may have in relation to my evidence.
Yes, thank you. Well, we received the rebuttal on the rebuttal yesterday morning, so we have read that, but obviously when the submitters, Winston Aggregates, appear this afternoon, we can perhaps get a little bit better understanding about the points of agreement and whatever remaining points of disagreement there are, so that is helpful. At this point, any particular comments or questions at this point? Okay, so what I propose we do, Mr. Bellamy, is to do a page turn on your Section 42A report. It can be somewhat tedious to do, but it will give us the opportunity to ask any questions or to seek any matters of clarification. I personally don't have very many things, but we'll see where we get to. Right. I think we can probably look to the section at 2.6.1, paragraph 17, where you talk about the deferral of matters relating to proposed land exchange. You will recall that this matter was raised in hearing stream 1, where the Winstones Aggregates sought leave for the district plan considerations, which were in relation to that matter, to be deferred until the wrap-up hearing, which is currently scheduled for December. Are you quite comfortable that there is sufficient separation in between the matters which relate to the land exchange and to the matters before us today? Is it entirely around the quarry? There's no crossover matters at all, which we need to be aware of at this time?
I think that's a very good question. In my opinion, there is a crossover or potential crossover with the matters relating to the amenity buffer area because that relates to the quarry amenity protection overlay, and several of those parts of those areas are potentially going to be exchanged, which would result in further mapping, but also that potentially affects the assessment of Area 3. That's my understanding, but Ms Armstrong can speak to that and the submitters can speak to that later.
Certainly.
That would be my only concern.
Have you, I know that you and Mr Johnston had a discussion with Winstones Quarries before you commenced your preparation of your evidence. Was there also related discussions relating to the fast track application in that meeting, or was it entirely focused on the quarry zone provisions?
It was more focused on the provisions that we were looking at this hearing.
Very good. Okay, thank you. I think we can move on. I'm at paragraph 25. Then we're on section 3, chapter summary. Certainly. Commissioner Muspratt.
Thanks, Mr Bellamy. This actually might be more of a question for the 42A report writer for the earthworks chapter. I'm just looking at paragraph 31, where it refers to earthworks provisions within the quarry zone. And I just noted when I was reading through the PDP that the actual rules in that chapter, the earthworks chapter, don't exclude quarrying specifically. There is explanatory text above the rules table, but no actual exclusions. So I just sort of maybe highlight that now for the later hearing.
I agree with you. I think that that's a matter for the earthworks hearing. Sorry, the hearing stream that involves the earthworks chapter.
Yeah, it is I guess it's the nature of the beast in terms of dealing with various different provisions which will need to be all integrated in at a later time. But in relation to earthworks, are you're quite comfortable that the quarry zone itself provides the necessary direction in relation to earthworking matters in the quarry zone, and isn't being left to dealing with another part of the plan for the same general activity?
The general approach we've taken in the review of the plan and the preparation for the hearings is to separate out some of those district-wide activities such as earthworks. So as a general rule, we haven't considered them when we've looked at individual area, the zoning provisions. I'm reasonably happy in that a lot of the work that relates to quarrying in terms of some of the earthworking type activities tends to be involved in the definition. However, I'd have to look at it. I need a bit of time to look at it if I was going to give you a definitive statement, because I'm not, off the top of my head, 100% familiar with the definition. I have to go back and check it just to make sure.
All right. All right, we'll move on. I go right through to paragraph 56 I'm on at the moment. Because we have the submissions and general support, which you discussed before that. I have to say there has been a little bit of confusion all the way through in terms of terminology, particularly in terms of the overlay. I keep on having to go back and see it. You're comfortable that there is sufficient clarity around the terminology for each of those all the way through the plan?
Another good question, and I agree that the proposed district plan, as it was notified, that there is a fair amount of confusion around the overlays and the naming. I am happy that we've managed to pick that up and address it as part of the Section 42 assessment, so that now it's consistent.
And just on that, how different is the ODP extraction area provisions to what's in the proposed district plan now? Are they essentially a carryover, or has there been reasonably significant modifications?
It was a straight carryover from the operative district plan in terms of the original area that was mapped, and I think it was a straight carryover as well, with the provisions that were related. It might have been slightly different, but the intent was carried over.
I'm at paragraph 60, Quarry Zone P1 enabled activities. You got some questions?
I just wanted to have a little bit more clarity. So the courts chapter includes provisions regarding Indigenous vegetation that are separate to the ecosystems and Indigenous biodiversity chapter?
That is correct. The intention of the provisions that were in the ODP that we carried over relate specifically to buffer zones that were created around the edge of or within the edge of the quarry zone, and in specific areas to create a visual buffer between quarrying activities and the surrounding zones.
And just in terms of the removal of any conservation activities, it appears that there's some alignment between you and Mr. Hopkins on that. Is that fair to say? Now?
That is fair to say. There's been a fair amount of to and fro through submissions and further evidence. They have argued that that there's no need for that particular provision within the rules, and that and as such there's no need for it to be included. And in my rebuttal evidence that I've supplied, I've agreed with them and agreed to remove the incorporation of that activity as a permanent activity.
No. Moving on. I'm at Courts P6, vibration. So I'm just wondering whether when we get Mr. Hunt involved in that fairly discrete issue, perhaps we'll leave the noise vibration issue until after we've gone right through your report and seek the views of, in terms of the Mr. Hunt and, sorry, I know your first name's Rose, but I've forgotten your surname.
Armstrong.
Armstrong, of course. And perhaps we leave those as a discrete issue until we've completed the remainder of the matters. I'm at paragraph 78, which is in relation to Eco R2 and Courts P7 relate to separate issues. And the provisions in the Ecosystems and Indigenous Biodiversity chapter relate to the maintenance of biological diversity and intrinsic values of ecosystems. We've been plan stopped on the ecosystems and Indigenous biodiversity provisions in the plan as notified. What remains in the ODP relating to these particular equivalent issues in the ODP that need to be integrated in with the PDP as we have it now?
I guess if I'm interpreting your question right, you're asking about what are the equivalent for the eco.
Yeah. Well,
yeah.
what's in the ODP which still exists?
So chapter 14 includes a range of rules that relate to areas of, I'm going to have to be careful with my definition, because it's one of those definitions that changes between ODP and the current RMA. So areas of significant Indigenous, I think it's vegetation off the top of my head. So there's a series of rules there, but they don't, as general, apply to private property because the plan change that was involved with those was never completed in the past. So we don't currently have a lot of rules that are in the operative district plan that would carry over that specifically relate to private property. As a general rule, they're there. But they don't, vegetation rules don't necessarily apply to private property, apart from there are some rules that relate to residential zones that have come through court action. I don't, off the top of my head, know whether or not they relate to industrial zones or other zones. I don't think they do.
Okay, well, it is a across the plan issue which we have raised before about what's in and what's out from the ODP and how that would be cross-referenced across to the PDP where these matters are raised. I think that might be helpful, Mr. Good.
Yeah, just to add a bit more detail to what Mr. Bellamy's just shared. Chapter 14 he was referring to includes all of the district-wide chapters in the ODP. In particular, I think it's chapter 14E addresses significant natural resources, significant cultural resources, and significant archaeological resources. What Mr. Bellamy was referring to was the list of significant natural resources, which includes, I guess it's our district plans equivalent of significant natural areas. So it's areas that are identified for the Indigenous biodiversity values, but it also includes areas that are identified for their natural landscape values. I should say that these don't apply to the quarry zone that we're looking at the moment, although they do apply in some open space zones that we'll be speaking to later. And then, as Mr. Bellamy was saying, there are Indigenous vegetation protection rules in our residential zones, which were added to the district plan through an Environment Court decision. Those are awkward, I would describe them as they're trying to protect Indigenous vegetation while also not running afoul of the restrictions in the RMA against blanket tree provisions. So they are protecting vegetation without protecting trees in some circumstances. So that's a challenging thing to get the head around, but that's certainly something that we can provide some written advice to the panel about how that actually works in practice.
That would be helpful. Any additional comments at this point?
Yeah, just a little bit more specifically, that last question. As part of your right of reply, could you please just confirm what, if any, operative district plan overlays and therefore potential provisions still apply to the quarry zone?
Yes, I can do that.
Okay, we can move on. I'm at quarry zone rules and standards. Quarrying activities, paragraph 87. At paragraph 91, there's the submitter is requested an amendment to the activity status for the Rural Quarry Courts R52. You consider that a restricted discretionary is appropriate activity instead of controlled. I've seen controlled activity provisions in Wellington. In fact, I worked on them for Kiwi Point Quarry. Is that not being thought of as a potential option, that the zone provides for quarrying, it's enabling of quarrying, but there are some matters of detail which need to be considered in the rule. And considering where we're going with controlled activities and with the new legislation. But have you got any particular further comment on that?
Not specifically, but I could look into that, bearing in mind your comments, and provide some further advice if you'd like me to.
I'm down to the standards now. Is there anything before that? So
I just wondered if you could, I sort of got a little bit lost with your paragraphs 110 to 112. If there's nothing before that, sorry, I might be jumping ahead. I just wondered if you could just walk me through your recommendation there, how you got to where you got to.
Is this with regard to the change of the geodetic datum?
Yes, in relation to Standard 1.
So, Standard 1, there was essentially there was a 1949 geodetic datum, and it's been updated, and the request is to update the standard to reflect the new datum. Ground levels change with time. This is to reflect that change, but bearing in mind that the existing height restrictions that we have are quite broad, and giving in mind that we are talking about something like 0.5 metre, I recommended changing it without a change to the specific height, maximum height. I think it could be argued that you could change the maximum height, but given the size and the distance from anything, it seemed to be, it didn't seem to warrant the change per se. It was easy just to leave it, in my opinion. Does that answer your question?
So, thank you, yes.
Just on standard S1, which relates to the height. How close are you to the submitter in terms of being able to agree a process? Because they have provided an amended standard, perhaps a more defined standard.
I'm not sure. I'd need to talk to Miss Armstrong as well and hear her comments on it. It might be that we are close. It might be that some more work is needed.
Sure,
Can't comment
we'll
at
ask
this
that of the submitter as well. I'm just raising it because on the face of it, standard S1 has a potential, depending on where it is, for a 24-metre structure. It's quite big, quite tall. So it would be really good to sort of avoid any confusion that there is, because it is quite, because you've got different ground levels and different heights relating to different ground levels, and obviously that can be assessed, but I'm just really trying to look at potential removal of any confusion that there is.
We could, I could look at that and get back to you.
And I'll be asking that of the submitter as well.
Just as part of that, looking at S1, could you look at, consider with which of the potential standards in terms of measurement for height could be most easily applied? In terms of, do you need a surveyor to confirm permitted activity status or not? Whether it be the maximum height or the alternative sought by the submitter. So just the practicality and ease of implementation.
Not specifically. I haven't looked at, or haven't formed an opinion on the evidence that was supplied over the weekend. So I'd still have to get back to you on that. It's something, I can look into you and provide to you following the hearing.
Anything else on standard 1? Hours of operation, exemption of emergency activities from the standard. I have one at paragraph 116. You agree we're an exemption for the operation of the standard should be applied for emergency activities. And the nature of the quarry zone requires that quarry may need to respond quickly to an emergency. What would you define as being emergency? Risk to life and property, or the quarry operator has a problem with a slip that needs to be remediated that because it's unstable, but there is no particular risk to life and or property.
I think that's a very good question, and put a fair amount of consideration into that when I was thinking about it. I don't think that a slip per se is an emergency activity. I think an emergency activity is a risk to life or property. It could be solved if the panel wanted it by defining what an emergency activity was.
Can you remind me whether emergency activities is actually defined?
No.
As a term?
It's not defined, and I don't think it's defined in the RMA. I think I went through some other legislation as well to see what it was defined as. I think we would need to define it if we wanted to be specific.
Let's have a follow-up on that one.
Yep.
I actually had the same question of what is an emergency activity, and I looked at sections 341 and section 18 of the Act, and it refers to unforeseen emergencies in terms of providing a possible defence in the case of prosecution. So I'm also wondering if there's a question of what would be an unforeseen emergency if you're looking to provide an exemption in the standard. Might not be quite as simple.
So I looked at this as well. My first approach was to consider whether or not the existing provision in the RMA provides sufficient sufficient flexibility and protection in terms of dealing with emergency activities and providing that protection. My opinion was that there are some things that are involved in terms of unforeseen activities. For instance, an example might be if there's a significant flood event happening or weather event happening and they have to make do some earthworks or something in a hurry to prevent that. So the question is, should that be dealt with through the legislation in terms of them doing the work and then applying retrospectively, effectively for that activity, or whether we should be providing for it as an activity within the rules and standards of the plan. And I was of the opinion that it was better to provide for it up front. Hopefully that answers your question.
Just on hours of operation, it's a question I'll ask of the submitter, but how reliant are they on a 20, do you know from discussions whether or not the quarry actually operates on a 24/7, 24 hours a day basis or not? It seems to me that when you're playing around with big machinery, then you're probably not wanting to do too much of that not at night. Might be for loading and unloading, I can understand that, but the actual quarrying activity itself.
I think the provision is carryover from the operative district plan. There may be a consent that allows them to do more than that. I'm not, I can't remember off the top of my head. I can certainly get back to you on that, or it's a question that we could potentially ask the Windstones. I think that the provision of an activity with a limit to hours is important given its proximity to other zones.
Okay.
Another follow-up. It relates to hours of operation, but it relates to, I guess, all consented or permitted activities on the quarry zone. And one thing that I thought would have been really useful for my consideration of the submissions in the 42A was to have a better understanding of what the existing certificates of compliance, resource consents and quarry management plan are. So what's in them, what are included. I think that sort of context would help the panel, what would certainly help me understand more what's being sought in terms of the baseline of what's consented, what's existing use rights, those sorts of things.
I can provide for you for the panel following the hearing, if you like.
Okay, we'll move on. I'm at vibration, and I suggest we probably ask Mr. Hunt's overview on where that's sitting at the moment. when we come to the conclusion of your 42A report. Mindful that we're also got your rebuttal statement as well. Which takes us right down to was quite a bit on standard S3 in your report. We generally defer to Mr. Hunt. So, where is your next question? S4. Right, perhaps we'll go to S4 and come back to the issue of S3 with Mr. Hunt. Okay.
I sort of got a little bit lost again, and I just wondered it might be helpful to see some sort of map showing sort of the various components of the setback overlay, the quarry activity overlay, where the QE2 is, the proposed land exchange, and the overburden disposal area. It would sort of be quite helpful for us to visually see all that. At the moment, it's very difficult to visualise all those components and to sort of make some sense of how the provisions work with them.
I can provide you with a series of maps at the end of this to.
Yeah, I'm just wondering while we're here, can we get the PDP maps up with the relevant overlays turned on for the quarry zone? And perhaps you can walk us through your understanding of the, I know it's in one of the Section 42A reports as well, but it is on the face of it, it takes a couple of reads to actually understand what's going on. Thank you, Mr. Gerd.
Just while Nathan is finding that information, so the operative district plan maps are not actually on our mapped GIS files, are contained within the, I think it's Chapter 6D in the business zone for extraction activities. It's an appendix at the end of that. Oh, okay. I stand corrected, it's been updated. So if we look at this here, this is the proposed district plan. And if you look at the grey area, that's the quarry zone. Nathan, can I get you to turn on the think it's under.
There we are.
That hatched area is the quarry protection, quarry zone protection overlay, which is the area on the rural zones. If you could turn on the amenity protection overlay, I think it is, which is down, Nathan. Is it the one? No, other one at the, there's another one somewhere. Which is it? Another layer
There we are.
somewhere. There we go. Oh, you can see it. So in light blue,
So, yeah,
you can see the areas there. So this is the area that we're talking about in terms of the quarry amenity protection overlay. So it's an area that is raised relative to the base of the quarry, and they are currently covered in native bush. The area at the top there, the larger area, is an area that's mostly due to be exchanged with the Belmont, well, my understanding is to be exchanged with the regional park as part of the land exchange and the rezoning of an area in the, what's currently in the regional park for quarrying. So
Sorry, can you just remind me again? Which is where is the area that is looking for
exchange.
exchange?
So that the larger of the two areas there, that's got lines on it, blue and blue, that area there.
That area there?
Yep.
And it would get swapped for what area?
There's an area that's not shown on this map, but if you go to the top corner, there's an area at the top of the quarry, just where it kind of joins that line. There's a kind of a semicircular piece of land in there that that is to be exchanged with the regional park for the quarry. My understanding is for disposal of quarry,
Overburden.
Overburden, yep.
So that's, the area 2 is looking at, that's the area that's likely to be exchanged. Or
This area here, yep.
Potentially. So area 3 remains.
Yep, that is correct.
And so just clarify for me what the blue hatched line is?
The blue hatch line or
Yeah. That one, yep, that Nathan's
that
pointing to.
that area there is the quarry zone protection overlay. So there's to the east of the quarry is an area of rural lifestyle zone land and rural zone land, and that area is covered by an overlay that limits, or requires a consent path for new residential dwellings, residential activity, or visitor accommodation, where they have to consider the reverse sensitivity on the quarry zone.
And so the hatched area, I thought that was the hatched area.
Sorry, the blue hatch is the Strange Roads overlay.
Oh, okay.
Sorry, I didn't.
Yes, well, we
Yeah.
confronted that one in the last hearing
Yeah,
as well.
Thank you, that's clearer to me now.
Yeah.
My apologies, my eyesight is not what it used to be.
Me either.
All right, thank you, that's helpful.
But just as a follow-on to that, Mr. Bellamy, just at your paragraph 153, you've said the standard incorrectly refers to the quarry activity overlay, and then the last sentence says the standard should instead refer to quarry activity overlay. Is that meant to be quarry setback overlay?
Yes, that's correct. My apologies for that. I as well, when I was trying to recorrect everything, there's a lot of different things that I've obviously made an error there.
Courts S5 Special Amenity Area Overlay, Quarry Amenity Protection Map Layer. I think this one is also highly related to Ms. Armstrong's evidence, which was included in your rebuttal. Because of paragraph 172, say the overlay mitigates visual effects of the quarry on the adjacent residential areas, particularly Manor Park and Taita. Some distance away though, aren't they? They're very distant views. The other side of the river, other side of the railway line, other side of State Highway 2.
That is correct.
Okay, I'm sure we'll hear some more about that. Quarry Zone is 6. And then we're into the Quarry Zone Protection Overlay Objectives and Policies, which are located in the Rural Zone provisions. I'm at paragraph 188. Okay, we'll go back to 181, which relates to the objectives.
It's just that amendment to replace new activities with activities. And when I read 184, you provide examples. Are those not examples of new activities? So the bulk and location of buildings changes, or a change in use or an intensity. Are those not new activities?
I've interpreted them as existing activities that have where there's a change in the bulk and location of something or an increase in the intensification. That was the intent, as opposed to a completely new activity, as in a change from, say, residential to industrial or home occupation or something. You know, there's not an obvious change to the actual activity itself. That was how I've read it and how I've assessed it. If you'd like me to relook at that, I could do that as well.
If you could relook at it and maybe think of it through the lens of, or consider it through the lens of, are there permitted activity rules that apply to these, I guess, extensions or changes to existing activities? Thank you.
Okay. I'm at paragraph 188. And again, it's the whole issue of including lawful established activities within a policy, which has been raised elsewhere in the plan as well, some sort of recognition for lawfully established. The convention is not to use that word within the plan though, is it? all those words.
Would you like me to address that with a follow-up, Lindsay?
Well, I just thought you might know off the top of your head because I think your recommendation on that is that the relief be rejected, particularly the inclusion of the metric proposed by the submitter about having a 500 metre buffer or within 500 metres.
Yeah, so my feeling was that this was a further extension beyond the quarry zone, quarry zone protection overlay. So this was a policy, change of policy so that it extended an additional 500 metres beyond the edge of what was already there, which would have significant impact on lawfully established activities and other activities that were already in those zones. And it might require some sort of assessment for, consequence assessment for other zones as well, because that would also bring into play, whilst this only applies to rural zones, the area that would be potentially covered would be residential as well. And I guess the question about, I'm not quite sure what the question about lawfully established activities, are you saying that the convention is to not include or to include those in a policy? Because
Not include.
yes, I would not advise including them as well. It's another, I'm not sure if I addressed that, I can address that.
It has been raised here, and we're in hearing stream 4, and I think it has been raised as well in previous hearings about lawfully established. We will, I think we'll be able to make our own, take our own view on that. Thank you. So just the map it's at the top of page 48. Underneath paragraph 190, just above 191. In the area which is rural zoned land within 500 metres of the overlay, what's there at the moment? Is there, it's bush clad hillsides, is it?
It's a rural lifestyle zone allotment, so it's small, mostly small kind of lifestyle lots with associated residential development on it.
So and to access those rural lifestyle lots, do they go on off State Highway 2 or off Major Drive access?
They're not off State Highway 2. They're off the.
So you've got to go up the hill and then down the hill
Yep.
to get to them.
Yep.
Okay.
I can speak a little bit more to that if you like. There's earlier we were talking about the highly constrained road overlay that's in that location. That applies to Liverton Road, which is a very windy, narrow road that services a lot of the rural residential areas or general rural areas in that area. So on the screen, just sort of flagging it with my cursor.
Yes.
As you get further away, though, basically outside of that dashed blue line, the properties are accessed from the western end via Kelson, which is accessed via Major Drive, and then some of the side streets of Kelson.
Thank you, that's helpful. Okay, I'm at 356 Quarry Zone Protection Overlay Rules and Standards. And there we can, we're looking at the issue of whether non-complying or a discretionary pathway is appropriate. Comments? Okay, well, I come to the conclusion. I'm just wondering whether it'd be helpful that we heard from Mr. Hunt and Ms. Armstrong now, and then we'll take a break, and then we'll go through whatever's remaining from your rebuttal. Mr. Hunt.
Yeah, good morning. My name is Malcolm Hunt. I'm actually assisting council with the noise chapter. I was called in to assess some specific matters raised by Submit, and they all relate to S3 of the quarry zone with the consequential amendment to S7. And I can just briefly summarise what the submitter was asking for, and through a small amount of deliberation, we've ended up in a position where the submitters, experts, pretty much in agreement with where we're heading, and we've also acknowledged the points the submitters made. But I can just summarise the 3 areas. It looks a lot of wording changes, but they are quite simple. The first one is S3 2B, which had 2 units for quantifying the noise from quarry blasting. So this is the airborne sound, and the submitter assessed that we only needed 1, and to have 2 might also introduce some problems if you measure it one way and not the other. So we've clarified that, gone with kind of best practice there, and there was just a small amount of discussion around that should be assessed, although it does apply to the facade of a building, should be assessed as if the building wasn't there, to deal with the effect of reflections, sound reflections off the facade. The second matter is in relation to notifying neighbours prior to blasting, and also that and a matter to do with monitoring, and rather than delete them as requested by the submitter, we've undertaken a bit of a review and decided that those matters are still important, but they would be better sitting in the quarry management plan, which can be more bespoke to the quarry and take account of the sensitivity of the receiving environment. So those are changes which deleted 5 and 6 from S3, and also dealt with 3.8 in relation to monitoring, and 9, and indeed 10. So the matters of importance for these are more management-based approaches, and how monitoring is to be done and how frequently, etc. They now rest in a summarised fashion in S7, simplifying the application of S3, which really leaves some more hard and fast standards like hours of operation, noise limits, vibration limits, which leads me to the third matter which the submitter raised, was in relation to the vibration standard for blasting received at occupied buildings, and these were in the notified version to be assessed under an Australian standard 2187 part 2, and as the submitter pointed out, we already have another standard for physical vibration protecting the building, and the lower limits for that accord with the generic vibration recommendations of the Australian standard, and perhaps importantly, avoided an issue in the Australian standard where it says the vibration limit is to be complied with for 95% of the blasts undertaken in any 1 year. And it raises a big issue there that you can't really enforce that until you've got a year's worth of blasting. And it really is a bit of imprecision there. So I took on board and investigated the issue of just going with the German DIN standard, which is the vibration standard to protect the structure of a building, and assess that at the lower limits for vibration for that standard actually will prevent or avoid undue annoyance for occupants of buildings as well. And it's all explained in my reports, which are attached to the East 42A report and also to the rebuttal. I followed up with a further assessment once the submitter's expert had a look at it. Anyway, that's led to a decision to slightly amend S311 and delete S312, which was the Australian standard, although it's worth noting that the Australian standard is still referred to as a blasting to be followed under S31, which is a blasting practice guidance. And I think that Australian standard is well suited to that, and it doesn't cut into that issue of 95% limits, which is seen as a little bit of an issue. And so in summary, what we've done is we've acknowledged the points made by the submitter. We've fine-tuned a few of them and taken out the management aspects and reporting aspects and popped them into the quarry management plan at S7, and left S3 as a more cut-down version with the precise standards we need, and which would be easier to follow and to prove compliance with for a user.
Thank you, Mr. Hunt. Looks like there's a large amount of agreement between you and Mr. Exeter.
Sorry, it's a large
There
amount.
is a large amount or total agreement between you and
Yes,
Mr. Exeter.
absolutely. I think the last
The material we got
rebuttal
yesterday
from it said
indicated that
that
that was the case.
there's no matters outstanding. Yeah.
Right. Any questions of Mr. Hunt? No, thank you, Mr. Hunt. Ms. Armstrong.
Kia ora koutou. My evidence that I've provided is focused on my review of the landscape evidence provided by Mr. Compton Moen in relation to the quarry zone and the removal of Area 3 from the quarry amenity overlay, and the height restriction removal related to specific structures in the quarry.
Ms. Armstrong, I'm just wondering, can you just bring the microphone a little closer? Could be me, but I'm slightly hard of hearing.
Is that better?
That's better, thank you.
Would you like me to start again?
Not necessary. I did get
Sure.
that. Thank you.
I understand I can take my evidence as read, but I can provide a brief overview if that's helpful before moving on to questions. In summary, I disagree with Mr. Compton Moen on the extent and level of landscape and visual effects that will result from the removal of the quarry amenity overlay. In summary, we disagree really on the value of the Area 3 landform to the local context. Mr. Compton Moen has an opinion that it has very little value, such that its removal will have a low and minor adverse effect on surrounding areas. In my opinion, although it's a relatively small piece of the escarpment within the scale of the overall landform, its location between the quarry and the residential context and its elevation means that it does actually contribute significant landscape value to the local context. The value comes from its screening of the quarry activities from the north end of Taita, from elevated parts of Stokes Valley, and from the river corridor. And with some of that screening is partial, some of it is directly from the east, and the northeast is quite a bit more substantial, and in many views it's fully concealed. It also contributes natural character, landscape and visual amenity value to the Hutt River and to the surrounding residential areas from its unmodified landform and vegetation on the eastern face. And it also provides a more natural shaping to the quarry overall, in terms of its fit with the surrounding natural landscape, which would make it easier in the end to rehabilitate and reintegrate the site back into the natural surrounding landform at the end of the quarry life. So overall, it seems to me that Area 3 is a main method by which the quarry manages its adverse effects on the surrounding context. And so for that reason, I've recommended that it remains. I think that there's going to be a higher level of adverse effect spread more widely than is indicated by Mr Compton Moen, relating to landscape natural character and visual amenity effects, and with some of those effects not addressed in Mr Compton Moen's evidence. Relating to the height restriction, I've recommended also that that be retained due to the unsurety of outcomes on skyline values from the relief as sought in the original submission. I have had a chance to have a look at the rebuttal evidence that was provided yesterday afternoon, and I see that there are some adjustments to that height restriction in a new provision provided for that. I haven't had a chance to have a look at that in detail, but it does look on the face of it as if it could be something workable. Yes, so happy to answer any questions.
Thank you. I'll just ask my colleagues first of all. Huh? Yeah, okay.
I just wanted to understand the differences between your assessment and Mr Compton Moen's, how it's possibly perceived different from my limited knowledge in this area, but I just wanted to understand you tend to have looked at a broader landscape when looking at visual effects, and I just wondered what drove you to do that? What was the reason behind that? And what's the catchment, if you like, a normal sort of catchment, if you know, might help me to understand that?
Yeah, there's different scales. Mr Compton Moen did look at Stokes Valley, which is kind of the more distant context that would be affected as well, but used an area that didn't have visibility, whereas there are actually quite a few roads in there lined by houses that do have a lookout to the quarry and that landform, Area 3. And although they're more distant, and so the north end of Stokes Valley is quite distant, but directly opposite to the east of Area 3 landform, although the context is more distant, it's at the same elevation. And so that kind of heightens the adverse effect for those dwellings. So landscape effects, I consider those away from the river corridor, because the river corridor is where natural character matters apply. And landscape matters apply in the corridor too, but in a context like this where the values are closely linked to the river and its natural surroundings, landscape and natural character kind of correlate quite a bit. So I looked further out at landscape effects on the suburb of Taita and Stokes Valley.
Thank you. Would you say that you only looked at perceptual matters?
Yes, relating to natural character I have, because I didn't have, I haven't done a full assessment.
Yeah.
And
In this situation, though, is that necessary at this level to do those other aspects, or?
Well, if I was doing a full assessment, I would certainly include findings from an ecologist relating to the vegetation on that landform. So I don't have any information on that, so I wasn't able to include that. But it seems fairly likely that removal of that vegetation is not going to be a positive ecology effect. It's likely to be adverse. The level of that is unknown at this stage to me anyway. I don't know if there's high value rare species or what there is, I don't know. But I guess the key point is that it seems likely to be an adverse effect.
And sorry, just one more from me. Winston had proposed a potential of a 10-metre landform or vegetation strip, and I realise that we haven't seen what this looks like or anything. Well, I haven't anyway. So I don't want you to give me a definitive answer, but I just wondered if you had some introductory comments about that.
Yes. I think it's more likely to have a greater impact on screening and closer views. So directly below Area 3 in the river corridor, because you're standing underneath the height of the landform and that extra height of the 10-metre strip, and then vegetation on top of that, the sight line is more blocked.
Yeah.
So in more distant views, it's probably not going to have the same impact. The 10-metre strip, I'm not quite sure how they're defining that, because it's a very steep bank there. So I assume that the 10-metre is measured horizontally on a map and not measured vertically up the face. And I guess my other comment would be that it doesn't have the same landscape value in that it's not, as proposed anyway, the strip is more like the form of motorway edge planting. So although it would have some screening and more distant views, it would kind of relate more to the urban form of the motorway, whereas at the moment the vegetation has a natural skyline and it's on natural land, unmodified landform on the eastern face anyway.
Yeah.
And so I think it has some benefits for sure, but it also doesn't mitigate effects of the quarry in the same way that the Area 3 landform does.
Yeah, sure. Thank you, that's helpful.
Julianne?
Ms. Armstrong, I just have one question. There seems to be a bit of discussion or disagreement between yourself and the submitter's expert on Section 6 of the Act in terms of which provisions apply. My question is whether you consider Area 3 to be part of the margin of the Hutt River under Section 6A.
Yes, I would, yes.
Thank you.
Yep. And that's backed up by notes into Tangi Ata Manu as to what can constitute a margin. You know, from a perceptual aspect, when you're inside the river corridor at Area 3 or north of there, it certainly forms part of the backdrop. It's seen together with vegetation at the river edge. There are little glimpses of motorway traffic, but by and large, it's seen coherently. And so it very much is part of that experience along the Hutt River corridor, as is the rest of the Western Escarpment in that area.
Can I just as a follow-up question, you've got, you see it on the map that's in front of us at the moment, but yeah, you have the river corridor and you have the walkway cycleway which runs along it, and it's a area of some use and overall amenity to the area. But when you go towards the quarry from the actual river itself, you've got State Highway 2 with all that State Highway 2 is. It's, you know, it's a busy road. So I guess I'm just intuitively I struggle with the fact that it's part of the river corridor. And I think you explained that it's part of the perception and part of the values and so forth on the river corridor. But the fact it's on the other side of a very busy road.
It's not always seen like that, though. It is seen like that southwest of Area 3. It's not seen like that in front of Area 3 and to the northeast of Area 3.
Because you're on a lower level.
Because it's screened predominantly by Area 3. The motorway is, if you look to the southwest,
Yeah.
most of the motorway is screened by Area 3, unless you pop around the corner and start walking south, then you see it. But from in front of Area 3 and to the northeast, you don't really notice the motorway. The vegetation on the other side of the river joins with the vegetation on the western escarpment, and there are glimpses every now and then of traffic in one or two spots. But from that recreational node at the base of Area 3 and towards Pomato Bridge, you don't really see the motorway as part of that western escarpment because of the vegetation.
Okay.
I'd also, just to add to that, in coming towards the quarry from the southwest, along the Hutt River Trail, you can see, there's a lot more vegetation on the riverbed on the western side, and so that helps to mitigate the effect of the quarry too. Although you do see some upper cut faces in parts. If you're walking on the Hutt River Trail, you've got that tall vegetation right beside you. If you're up on the top of the stop bank, it merges and the vegetation comes along, Area 3 comes down, they join together in some views, and they kind of envelop the quarry. When you get to more in front of Area 3, there's less vegetation on the western berm alongside the river edge. The area, that kind of berm is more open in character, right down to the river edge. And so Area 3 therefore has a kind of greater role in that part of the river corridor in wrapping around the quarry and integrating it more into the hills. So with that removed, you would still have vegetation on the eastern berm at the base along the highway and potentially in that strip. But the quarry would become a much more dominating element in that part of the river corridor.
Okay. If we're going to go to the quarry tomorrow, and we will also take the opportunity to look at, I wouldn't say all of the views that in Mr. Compton-Moen's original assessment, but if there had to be, say, 3 really important perspectives to view it from, where would they be in your view?
Aldersgate Grove in Stokes Valley. Poor old Aldersgate Grove cops everything. It's only got a few dwellings on it, but a more distant view in Stokes Valley, because the views from Stokes Valley, because they're at that greater elevation, are surprisingly, I think it would have a surprising impact. And other than that, probably inside the river corridor below Area 3 at the recreation node there.
Some off Tider Drive there.
Yes.
Yeah.
Yeah. And also potentially along Farmer Crescent, where there are open grassed areas in there, so the kind of the residential context in there gets views of that landform, which because of its elevation kind of seems closer to the context than you'd imagine. And there's new complexes in there of 2-storey dwellings that kind of look out to that landform. Yeah.
Okay, thank you. I haven't discussed anything with my colleagues, but do you consider it as worthwhile having a discussion, probably not formal conferencing, but a discussion with Mr. Compton-Moen to work out where, really this is the nub of the disagreement, but isn't it, is relating to Area 3, whether it should be a 10 metre strip defined on a plan, or whether it should be this larger area and the plan is notified.
I'd be really interested to see some more graphics about the effect of the vegetation on the 10 metre strip. So I suggested that perhaps some more visual simulations would help, and I think they would. Yeah, I think it could be worth a discussion, yes.
Okay, thank you. I have no further questions. Thank you for that. Will you be around this afternoon for when Mr.
I'll,
Compton Moen gives us
I
evidence,
haven't-
or looking at it online if you need to?
I hadn't been asked to.
Well, I'll leave you to talk to Mr. Bellamy
Okay.
about whether you need to be here physically or
Sure.
whether you can potentially be informed when Mr.
Sure.
Compton
Yep.
Moen gives us
If I'm
evidence.
needed, I can be.
Okay, thank you. I'm just wondering, it's 3 minutes to 11 now. I think we'll take the morning adjournment now, and then we'll deal with the remainder of your rebuttal, Mr. Bellamy, and then we'll talk about the other zones as well with the other reporting officers, of which there's actually not a lot to talk about in either, but thank you. We'll adjourn until 11:15.
Whatever you decide to do, like if you'd like to be here to be able to do it, that's fine. We will do it. It might help if that's way if they, all if you want to watch it online.
I don't,
While you guys would it make sense would I roast him?
oh, here.
Because he's here
Right.
and you're all sitting around, so I just thought we've got some more of
I'm
the
completely happy
images
to
that
do that.
you were.
I think as long as it's not compromising anything, I'm not sure, like, I suspect it's probably fine. I just want to double check and make sure that there's no, because I'm not sure about how this process works in terms of it. It's clear that it's probably, that that's probably fine, but I'll just check with Nathan and just make sure that there's no procedural issues that we have to worry about. I don't think there are, but
No, I think that's what Lindsay was
Yeah,
suggesting. But I mean, we went round in circles on Friday afternoon at on those RL levels as well. So it's like, well,
Yeah.
well,
you
yeah,
know,
so maybe that's good. I mean, I think if we can get that, that's great. I'm just double checking with Nathan, just so
That would make
got some
timing wise
goodies
if
as
we could
well.
do that.
in terms of some
cool.
stuff.
So I'll put a check with Nathan now, just confirm that.
Kia ora, we'll recommence hearing stream 4. So where we left it was we were going to go through the rebuttal statement for Mr. Bellamy, and just with any matters arising from that, which we haven't already talked about. So I have to say I don't have too many more questions myself, but we'll just go through that with my colleagues as well. So I'm at 4.4.
I just had a couple of, just a question in regards to Courts P7 at your paragraph 4.28. You say that you don't agree with Mr. Hopkins' evidence and submission on P7. You don't agree with his assessment. But I'm just not sure what your reasonings behind that was. Is it just that your reasonings are presented in your Section 42A report? Oh, I probably,
Oh, no, I'll do.
Really good question again. Maybe I wasn't clear enough, and maybe I need to be a bit clearer about how I answered in that assessment. I guess I was more looking from a point of view that the purpose of P7 it relates not so much to Indigenous vegetation per se, but to the amenity buffering of, or retention of amenity buffering, and the mitigation of the effects of visual effects of quarrying on the adjacent zones. And that is the only provision in the policies that really provides for that. So that's that was my position, and I probably wasn't. Maybe I wasn't clear about that. Maybe didn't outline enough. And I can prepare something at the end of this if you'd like.
I think if we just maybe gloss over it in your reply, that would just be helpful so we've got the words in front of us. I mean, I was trying to scribble them down, but. So what you're saying is that it's not just about visual amenity, it's about amenity overall.
Yes, maybe I've misinterpreted. There's a couple I have misinterpreted Mr. Hopkins' evidence in that the way I read it was that it was mostly about vegetation and really the intention is more about the visual amenity than vegetation.
Oh, yeah, sorry. Yes, thank you. That, yeah. No, that's okay. But if you could just put those words into your reply so that we have them. Thank you.
Could we wind right back to 4.7? And this is perhaps one of the areas of disagreement between you and Mr. Hopkins, and that is in relation to two things. One is the matter of determining who's an affected person for a specific consent application. And the second is whether or not it should be a non-complying activity or a discretionary activity, restricted discretionary activity. Do you, elsewhere in the plan, and perhaps Mr. Good may be able to comment as well, is there any rules that require notification of a specific party when a consent application comes in elsewhere in the plan?
I don't believe so. It has, as a general rule, we don't identify, as a general approach, we don't identify specific persons in terms of requiring an individual person place to be notified. It's if something's non-notified or fully notified, that's the way things work. So the answer to that would be no. I don't think so. Nathan might be able to. Mr. Geard might be able to elaborate on that.
I was just going to say I can't think of a particular point except, and Mr. McDonald here might be best placed to answer this because I believe there may be something to do with the infrastructure chapter where I believe it's Transpower may have regulations that require direct notification, but I'll let Peter comment.
Yeah, it's the protection of infrastructure chapter.
Speak up into the microphone, please.
The protection of infrastructure chapter that has rules around controlling activities in the National Grid corridor. And there's a notice saying the notice of an application must be served on Transpower for consents under that rule.
And what about NZTA in relation to activities adjoining the state highway? Is that another one which is a possibility?
I'm not aware of any myself.
Okay, thank you. The second matter is non-complying activities for sensitive activities or not. And we'll hear from the submitter on that this afternoon. But it is private land which adjoins the quarry, and your position that non-compliant activity is too high a burden in terms of the gateway test to actually justify that approach?
That is my position. I think my assessment is that the Quarry Zone Protection Overlay is specifically there for reverse sensitivity, or the assessment of control of reverse sensitivity from activities within that overlay in the rural zone. So it's appropriate to have a rule that looks at reverse sensitivity, but I don't consider that a full non-complying activity is justified in this case. I don't necessarily see what it would add to the consideration and assessment of the the proposed activity. It does require a slightly different assessment of the policies in terms of how a decision's made, but the reality is that this is specifically an overlay to look at reverse sensitivity.
Okay, thank you.
A follow-up question there. It's been suggested that the focus on effects experienced at a particular location may, rather than looking at the effects on the quarry. So I just want to, the matters of discretion that you've proposed, do you think that they're adequate to be able to address reverse sensitivity effects from both sides of the coin, shall we say?
Another great question. I considered this for a while in terms of what Winstone's submission was and further evidence was, and trying to work out, was there a way to signal what kind of things would increase reverse sensitivity, and could they be included in a listed to basically aid the applicant or anyone that was on that site and aid the person who was processing an application for resource consent in their decision making. The things that I took out of, they're mostly things that are mentioned in the NPS National Policy Statement for infrastructure, that relate to infrastructure in terms of well-identified things. They've also been in district plan in the past. I also added in, I think, visual effects there as well. I did wonder, originally when I drafted the rule, I didn't include those things because I thought it was better that reverse sensitivity was just left to be reverse sensitivity of a broader context. So I take the recent submission by Winstones on board. This at the time, my assessment was that this would provide better guidance for maybe clarification, but I do take on board the evidence that was provided on Friday by Winstones regarding does it maybe too tightly bind, is it likely to limit the consideration of what actual reverse sensitivity is, and I haven't had time to really come to an opinion on that yet.
No, that's fair enough, but thank you for that discussion.
I have two kind of follow-ups as well. That's all right. We'll start with Mr. McDonald. You mentioned the Transpower rules that included clauses around consultation. Are those restricted discretionary, like standards?
I think it's in the non-complying arm of the rule.
Okay.
And it's just an advice note.
Advice note.
Yeah.
Okay.
Yeah.
Second question for you, Mr. Bellamy. It's this reverse sensitivity question. What, reading through the section 32, I didn't. There are provisions in the RPS that deal with things like dust, like mandatory policies that must be given effect to, which refer to quarrying activities, like policy 1, I think, is a mandatory policy. And I'm just wondering if you could, it doesn't seem to be in the 32. I'm wondering if you could take a look at that policy and any others that might be relevant. I think off the top of my head, from memory, it's possibly policies 1 and 2 of the mandatory policies that deal with dust, odour and smoke and reverse sensitivity. And I think there is specific reference to quarrying in there. And just provide an update in terms of your thinking on whether or not the provisions, the rule framework gives effect to that.
Yes, I can do that. I'll provide it after the hearing.
Thank you.
I'm at Courts S1, the height issue, which appears that there's still a little bit of distance between you and Mr. Hopkins about the standard itself. My understanding of that standard is you can build up to 24 metres below RL, whatever it was, 45 or something like that, then 12 metres above that for ancillary quarry material. 431, Mr. Hopkins is wanting to exclude radio towers, cell towers, support structures and cement silos. Do you know approximately where on these plans RL 45 is?
I have to admit that my mind is just gone blank at the moment.
That's all right. I guess the reason for the question, and I'll be following it up with Winstones this afternoon, is that, you know, what is the justification for very large structures, you know, in below RL 45, which at 24 metres is 6 stories, and 12 metres, which is potentially 3-4 stories in height, just to use an equivalent, particularly for things like cell towers and support structures and a cement silo. Is that realistic or not?
It's a great question. The existing or the proposed height restriction relates to the existing rule in the current operative district plan. The exemption that Winstones have asked for is beyond that. In terms of the existing rule, when we looked at existing consents and other things that have happened, complaints, we didn't have any information or any evidence that would suggest that the plan wasn't working or that the rules themselves were a problem. I guess my assessment was that by removing those activities, those particular structures from the standard, it was providing quite a significant potential effect, depending, be it a cement silo or a cell tower or something large, that would not then be assessed in terms of what its effect on the surrounding area was. So I'm not sure if I have answered your question, but that was the thought behind it. In terms of what the basis for those two height restrictions, no, I hadn't given any thought to.
But they were in the operative plan.
They were in the operative plan, yes.
Exactly with that datum.
Yep.
That you can permit it up to 24 below it, and then permit it up to 12 for ancillary quarry-related activities.
That's correct.
Okay, thank you. I don't have any other questions on your rebuttal. I'll just ask my colleagues in relation to the quarry zone.
I just had one more. Rebuttal, paragraph 4.48, where you're agreeing with Mr. Hopkins' amendment to policy 6. My question was just I understand the change to the policy in terms of better aligning with the rules and the standards. My question is it as useful with the amended wording in the context of processing a resource consent that doesn't comply with one of those standards?
I'd have to get back to you on that. I would have to consider it. I can do that at the end of this hearing if you'd like.
Or you write a reply, you don't have to provide it today.
Any other questions of Mr. Bellamy on the quarry zone? Okay, thank you.
Can I just round out some of the information we provided on that protection of infrastructure chapter notification? I had mentioned that I thought that was as a result of some regulations. I've just had a quick look at the resource management forms, fees and procedures regulations. And regulation number 10 is on the service of applications for resource consents or for review of conditions. So that sets out some specific circumstances where consent authorities have to serve notice of an application, and which includes the normal notification test under section 95B of the Act. But point 2I of that regulation specifically says that Transpower New Zealand needs to be served notice if the application or review may affect the national grid. So it's that regulation that has resulted in that advice note in the protection of infrastructure chapter.
Yeah, I know in the case of Wellington City, that activities in the air noise boundary is one of those where I don't think the airport company is specifically included as being required written approval, but in practice, they get every application for a sensitive activity inside the air noise boundary. And it could be that this is in a similar sort of situation. But we'll do a little bit more thinking about that in terms of questioning for officers after we've heard from Winstones this afternoon. All right, thank you. Who's going to go first in terms of the other matters? I don't mind.
We could just go in order that we're sitting here. I
Sure.
could cover off the open spaces and then,
Yeah, again, I personally don't have a lot to ask here, but others may. So over to you. So we're going to deal with open space and recreation zones first, then hospital and anything relevant on the tertiary education zone as well, and then the Marae zone after that.
okay. I have a brief addition to my summary statement from earlier today. I'll take most of it as read and just address the issues that are specific to the open space zones. So, the overview of the open space and recreation zones. The proposed district plan includes 3 open space zones: the natural open space zone, sports and active recreation zone, and the open space zone. Few submissions have been received on these zones other than in relation to relatively minor rezonings. There has been a request to rezone land from natural open space zone to medium density residential zone. The natural open space zone is characterised by low levels of build development and high natural values. The medium density residential zone is characterised by multi-unit developments. Changes in zoning need to consider the surrounding land, natural environmental values, ownership in terms of whether it's publicly or privately owned, and the provision of infrastructure. In terms of issues relating to the submissions, Kelson Heights Limited has made a submission relating to the rezoning of a portion of a site at 64 Waipanami Road, Kelson, from natural open space to medium density residential zone. For the submission, they're requesting the rezoning of a piece of land from natural open space. My recommendation in my rebuttal evidence is the same as it was in my section 42, which is essentially to retain the zone. However, as a matter of course, I would revisit this through the right of reply phone submitted presentation on at the hearing. The issue essentially is that a portion of the natural open space zone may have to be included in earthworks, and that the submitter would like to have it rezoned to medium density residential zone. My assessment of the section 42 was that the earthworks provisions for the natural open spaces were actually more enabling than than the ones in the medium density zone, and I wasn't quite sure that they would be achieving the purpose of their submission. I'm happy to answer any questions the hearing panel may have in relation to my evidence.
Thank you. Ask my colleagues.
I have a question, just a clarification at paragraph 122 of the 42A report, where it deals with Margot Fry and Ian Turner's submission opposing natural open space zoning. Just their submission reads as if they own the affected land. I just wanted to confirm that you've checked that and it's actually council-owned land, I think is what you've said in the 42A. I just wanted to confirm that.
That is correct. Parts of development require riparian strips or other land to be taken off when land is subdivided, and that's what's happened in this case. So there's public land, there's strips of public land along the river in these locations.
Right, just jumping to paragraph 141. This is about the 95 Kingsley Street zoning of natural open space. Just thinking about the National Planning Standards zoning framework, is that the best fit for that piece of land in terms of the intended uses as natural open space? And you can come back to me on that, but just looking at it, yeah, if you could review the National Planning Standards zoning framework and what the submitter is saying, and you're free to answer now, or you can come back to me.
I'll come back to you. I think when I looked at these, I can add a little bit in terms of effectively an access point. Sorry, it's effectively an access point to the adjacent reserve, and on that basis was the basis of my recommendation from memory. I can come back to you, my right of reply.
Thank you.
If it's helpful, my colleagues on the right and myself visited Kingsley Street as a result of the residential hearings and the submissions of Silverstream Park Christian Centre. So we're pretty familiar with that.
Follow-up question. Is it the zoning, or is it a combination of the zoning and the specifications on the right-of-way that's over that area that is the part of the Silverstream issue? Is it about access for them predominantly?
I'll have to come back to you on that, because I can't honestly remember right at this moment in time, but I can.
No problem. Thank you.
It's not a biggie at the end of the day, but it did intrigue me. Your paragraph 86, when you talk about keeping of goats, you've got a statement there which says goats are used in the rural environment to manage pest species, but have the potential to impact on areas of indigenous vegetation. Where did you get that from?
Sorry, that was probably my own experience. I used to be the chairman of a Marae Trust in Island Bay that has a reserve there, and we used goats to manage invasive species. We neutered them. We had them chained up and inside a fence, and that was our experience. They were pretty good at keeping invasive species under control, but they also were a threat to, if you let them loose, they'd eat everything, basically.
Yes. No, I live in Island Bay. I know exactly where you're talking about. I know with the Wellington City District Plan hearings, the keeping of goats was a real issue in Makara, Ahari Valley, because they're just rampant, they're everywhere. Thank you for that. Your paragraph 142, when we're talking about the Silverstream Park Christian Centre as well. At your last sentence in 142, you say, while development of the site could be restricted by the proposed zoning, this is minimised by the right-of-way provisions. And I think this leads on from the question Commissioner Burge asked you as well. What do you actually mean? How are they minimised by the right-of-way provisions? Seems to me you've got Legal Road, which goes to the end. There's a stub road and goes into a reserve after that. And we did go and visit the site in relation to other matters to deal with the submissions. But I just wasn't too sure what you actually meant, how the proposed zoning is minimised by the right-of-way provisions.
These questions are well-founded. I'll have to come back to you on this if I can. From memory, I think there is a right-of-way there, and the right-of-way kind of restricts on what can be done on the site in terms of, because right-of-ways have those things on it, but I'd have to go back and check and then and then kind of provide a summary for you, if that's okay.
We don't have, the submitter's not here, and they haven't provided anything to us. It was just, I just wasn't quite sure what you meant. And sure, you can come back to us, but at the end of the day, it's not a significant issue. I don't have any further questions on natural open space. No?
I do, just one regarding the Hutt Bowling Club submission. It's probably not really a question, it's just something that I've noticed. Bowling clubs nationwide seem to be having quite a hard time retaining and recruiting new members. So it seems to be they're looking at other alternatives. Do they actually have development plans for the site? Or are they just anticipating a future possibility?
My understanding, it's anticipating a future possibility rather than anything definitive. Yeah. I think if there was something definitive, then recommendation might have been different.
If I can add to that point, I believe that there has been a resource consent application at some stage for that site, but I need to get that confirmed by our resource consent team.
That's okay, it was just more of a general comment. Thank you.
Okay. Thank you, Mr. Bellamy. Presume we're now on to you, Mr. McDonald. You prepared a summary for us.
Yeah, I prepared a summary statement, so I'm happy to read from that and then go to questions if you have any.
Sure, thank you.
My name is Peter McDonald. I'm a senior policy planner and I'm the reporting officer for Hospital Zone and Tertiary Education. So as a brief overview of the zones, the Hospital Zone is centred on the Hutt Hospital campus in Bulcott and includes some adjoining private facilities as well. And it generally carries over the approach of the community health activity area in the ODP. The Tertiary Education Zone contains the Welltech in Whitiera, New Zealand campus in Matone. And the ODP didn't have a special purpose zone. It was dealt with as precincts in a couple of other zones. the issues addressed by these zones, I think, are pretty straightforward, and they haven't attracted a lot of submissions. I have dealt with the submissions we have received in our report, and there was one table statement from Health New Zealand in response to Section 42. So just addressing that, they considered that the Section 42A mischaracterised this submission. So just on that, I understand the key point of difference between myself and them is that their position is it's necessary to delineate specific provision for the hospital, and that this is required to give effect to the MPSI, the natural for infrastructure. That they did sort of raise similar points in the original submission, which I consider dealt with by the report. And I don't think the table statement by Health NZ introduces any new information to change my assessment. But to restate my position, I agree with Health NZ that the MPSI provides direction for enabling infrastructure, including additional infrastructure, which is a new term, and includes Health NZ facilities, and that this direction is not applicable to other private healthcare activities. I don't consider that it necessarily follows that that alignment with the MPSI requires that Health NZ operated facilities are provided for in a way which is delineated or elevated above other healthcare activities. And I consider that the hospital zone is highly enabling of healthcare activities, including the hospital, and it generally aligns with the MPSI. Yeah, and there's no significant points of contention for the tertiary education topic. And there were some general submission points on urban design policies, which are pretty broad across most zone chapters, which I've tried to be consistent with in my response.
Thank you, Mr. McDonald. The submission from Health New Zealand was received late. Has that been accepted, or would we make a determination on whether or not to accept the late submission?
I've addressed that in the Section 42.
Yeah.
So, yeah, I've sort of laid out my thinking in relation to the, I guess, the criteria for accepting the late submission.
Yeah.
And I think, from what I thought it could be accepted, I guess, following that criteria.
Yes, no, and that's useful, but it's for us to make that determination to accept it or not. Thank you. No, I don't have any questions on either of those zones. I'm very familiar with the tertiary education precinct from a number of years ago now. Hospital, tertiary. Well, thank you.
Oh, sorry.
Oh,
Sorry,
sorry,
just slow off the
Julianne.
mark. Look, I just for, my own benefit, this Urban Edges submissions and the use of pedestrian dignity, which you've suggested amending because it's ambiguous. What happened to the word? I think they asked for accessibility, but that, I think you've recommended, removing that word dignity, but you didn't suggest putting accessibility in. Was there a reason for that?
I might be able to assist with that because this, the Urban Edge submission crosses
Yeah,
all
I
of the
think
zones. And
Yeah.
there was quite a lot of discussion with Mr. Davis at Hearing Stream 2 on this exact issue. And he has, the word dignity has been removed, or has been recommended to be removed as on the basis of that submission and replaced. And we didn't hear from Urban Edge at all. But it's also been, when the urban design policies kick in, it's a similar submission across all of the zones.
It could be that part of their submission was dealing with aspects of zone policies which were more specific to, more specific to zone policies of other zones rather than this chapter, but I might just need to review that. Because there's a lot of, it was very broadly worded across a lot of zones, and not everything they were saying was specifically applicable to this chapter.
Yeah, no, I fully understand the suggestion to remove the word dignity, but I thought that, yeah, the request for accessibility to be added in hospital zones and things like that might have some merit. That was all, but yeah, you can
I
pick
can
that up
have
if you
a-
think worthwhile.
Yeah, can have a look at that.
No other questions of Mr. McDonald? Thank you. Move to Ms. Bennett. And we have a hearing summary statement on the Marae zone. Kia ora, welcome.
Kia ora tātou katoa. How's it going? Ko Tokerau te maunga, ko tākou te awa, ko tākou te marae, ko mā tātua te waka, ko Ngāpuhi te iwi, ko Crystal Bennett tōku ingoa. My topic is the Marae Zone topic, as well as some of the other Te Ao Māori chapter values. An overview is the Marae Zone is really about recognising the unique role of the marae in Lower Hutt. Being the 7 marae, it enables mana whenua to continue to undertake marae activities and development according to tikanga. I consider the Mayor's Zone to be in accordance with the RMA, sections 5, 6, 7 and 8, particularly sections 6E and 8 because it recognises and provides for the relationship of mana whenua with their lands and taonga. There's a couple of key points that I wanted to point out, and that is to acknowledge the mana whenua marae being Te Tata o Te Pō and Waifetu. These 2 marae are supported through the Tākai Here Agreement between Council, and the other 5 marae serve as important community gathering places. I also wanted to acknowledge the submitter from Te Atiawa and their aspiration for land return. Even though the return of the land is out of the scope of this hearing, we are bound by the applications of zones and rules in the RMA. That's a matter under Land Tenure of the Resource Act 1977, and it may also involve Te Ture Whenua Māori Act, which has its own consultation and process there to go through that. My recommendations focus solely on ensuring the zoning does not preclude future cultural aspirations that mana whenua may have. I did provide a historical narrative relating to Te Whiti Park and the wider scope of Waifetu Pa. An example of that is you've got the Waifetu Marae and the papakainga surrounding it. Then you've got the Waka building to the north of that. And then across the road, you've got the health unit run by Te Atiawa. You've also got the radio station. But the Waifetu stream flows through Te Piti Park. And then you've got Pukeatua in the hills. So mana whenua see that as a whole unit. However, Te Piti Park is separated. So it's kind of, they see it as spiritually connected, the awa, the maunga, as it was back then. That pretty much sums up the hearing statement. I'm happy to take questions from the panel. Kia ora.
Thank you. I'll just ask my colleagues.
Tēnei te mihi. Kia a koe, Ms Bennett. Thank you for your overview. That was really helpful. Just a question around, from your summary that you've given us today, in terms of paragraph 6. So, the distinction between urban marae and mana whenua marae, you were saying that all 7 of the listed marae are mana whenua marae rather than urban marae? Is that?
Oh, Carl, the 2 mana whenua marae are Te Tatua Te Po and Waifetu, which is subject to the Tākai Here Agreement. The other urban marae serve as key community strongholds. Although the marae zone rules, they focus on, them together, mana whenua have a different perception of how they should be treated.
Okay, thank you for that. So, and that's particularly these Te Atiawa, these 2, Te Tatua Te Po and Waifetu that those structures, those wider structures are applicable. Okay, thank you. Actually, maybe you can ask yours while I just find where I was.
So just if you could go to paragraph 297, I just wondered if you could give me so that what I got from it was that the definition of commercial activity includes administrative offices, but the definition of marae includes ancillary commercial activities, but excludes ancillary administrative. Activities such as offices, and I just wondered, is that correct? And that just seems awfully complicated.
Yes, it came about because the commercial activities, it's kind of can be used in marae such as selling goods on site on the marae, like weaving and stuff like that. So mana whenua didn't see office administration as being part of that, but I agree with what you've interpreted it as and should be taken as such.
Is there an inherent problem with that though? For the marae, I'm thinking about, because obviously they have administrative activities. In terms of them, is there an issue? Is it just managed okay without that being included, or?
Yeah,
Yeah.
it's managed okay,
Yeah.
without it.
Okay. And I just wondered, there's a baseline of 200 square metres for commercial activities, and I just wondered, where did that originate from, that area?
It originated from the underlying zones, particularly residential areas and the commercial zones itself, to kind of be consistent throughout the plan.
Okay.
Originally in the operative plan, the community EB zone, which the Marae zone replaces, it was about 100 square metres, so it's
Okay, so
increased.
it's increased to be more in line with the commercial
Yeah.
zone. Yeah. Thank you.
Ms. Bennett, I was just wondering at paragraph 250, just this just kōrero at paragraph 259, around, hold on, urban design, future urban design policies, Māori design is. And this is just a question from me. Is there any use in this rohi of something existing guidelines like the Te Aranga principles? Could that be applied, or?
It could be applied. At the moment, most mana whenua in urban design is fed through the Kāhui group. And while there's no Māori urban design guide at the moment, there is one planned for the future to steer the council in how Māori urban design is put throughout.
Just a follow-up from that. I just know if, that the council is preparing design guides to sit outside the plan. Is this likely to be part of that design guide, or the idea, or is it likely to be separate? And
It's like to be separate, maybe as a urban form guideline, as an appendix.
okay.
Just talking about those future aspirations that for Te Whiti Park and you just discussing the balancing of making sure those don't get precluded. I was just interested to, I think about your paragraph 285. I was just interested to know where these conversations with the council are at. Is that also part of the Tākai Here memorandum, MOU as well, that sort of ongoing kōrero about these aspirations?
Yes, definitely, and also through the Kāhui mana whenua group. And for the Marae zone, particularly when we met with the different marae, they were wanting to have an avenue to practice their tikanga values. So that's why one of the strong objectives is to enable that, because largely they're all existing marae, but if they wanted to develop it further, it's pretty much keep in sync with the underlying zone rules for height and that sort of thing, so that it meshes in, but enables them to carry out their functions as well.
Sorry, just at paragraph 292, the temporary emergency management activities. Do they, just remind me, do they have a definition in the PDP?
I know temporary activities has a definition, but I'm not sure if you're aware that usually in an emergency, the marae become, and that's also another reason why Te Whiti Park was, Mana Whenua want that returned, is because they do use that field in those times for people to gather in emergencies.
Okay, thank you for that.
And I don't have any questions either. Thank you for your time and the effort you put into this. I think, well, we are going to adjourn now until 1:30, which is when we have the submitters on this afternoon. Kia ora, good afternoon. We'll recommence hearing stream 4 of the Hutt City proposed district plan. Two submitters this afternoon, the first being Kelson Heights Limited. Gentlemen, welcome. We have your evidence, and perhaps you'd like to run us through that and comment as appropriate.
Thank you. Good afternoon. My name's Cameron and I'm with my colleague Ian, and we did a submission on the proposed district plan on behalf of Kelson Heights Limited. The site is known as Kelson Heights and is located at 64 Waipunamu Drive. This site and development has had a rich planning history with a plan change that originally under District Plan Change 48 rezoned part of the development from hill residential to general residential, and part of that, and within this district plan change, also rezoned part of the area to general recreational activity area. Within the proposed district plan, it is seen that the general recreation activity area is retained as natural open space zone, and the remainder of the site will be medium density residential area. The original submission was to rezone the natural open space zone to medium density residential. And there are a couple of reasons for this. The first reason is that throughout the consenting process, there have been aspects of the general recreation area that council no longer want to be vested as reserve area, so will be held in private ownership. And secondly, just for the future use, once the subdivision and development is completed, will essentially create a tidy district plan in the future. So on that first point, a resource consent was granted under RM 250229, which specifically creates an allotment 302, which is within the evidence shows that it's not going to be vested within Hutt City Council as reserve, and therefore remain in private property. This is the major reason why it should be rezoned to, at least this portion should be rezoned to medium density residential, because it allows the developer and to continue with the, allows the developer to develop this area in accordance with the surrounding area. And there's no way, there is, it is unlikely that the objectives and policies of the natural open space zone will be met if this is to be held in private ownership. The second portion of this is resorting to the remainder of the natural open space zone, where there will be, until the legal boundaries are defined, there is a risk that the future allotments will be subject to dual zoning. And if the future owners will eventually look to do a subdivision on that land, on the usable portion of the land, they will need to start to address dual zones within consent applications, which just creates a further burden for any future owners. The original submission mentioned earthworks around these areas, but there is a current consent being processed by Hutt City Council which enables the earthworks for the development of the site. So it is, whether that's granted or not, will determine where the earthworks will be. So once the further subdivision comes along after that, we'll create the legal boundaries and the portion that will be vested to council. And we believe that it is suitable for the portion that is vested to council to be zoned natural open space, which might have to come later in a separate plan change further down the track.
Or otherwise is vested as reserve and then administered under the Reserves Act specifically, which would give council the ability to put its own provisions on the management of that land in accordance with its actual values. So that's much more value than a specific plan change. And that Reserves Act vesting would reflect the actual boundaries that are finalised or completed once the development is fully implemented.
Okay, it all sounds a bit messy from the face of it. So what's the position of Hutt City Council in terms of the land that they would require as a reserve? Is it just lot 300 and not 302? Is that your understanding of what is to be vested as reserve?
Under the current resource consent RM 250229, yes, that is the only part that's going to be vested.
And
But-
it's my understanding that 302 is not going to be taken, or council has not taken 302 because it doesn't have open space values.
Okay, so just to get to the nub of this issue, your preference is that, I think your submission wanted the whole area to be rezoned, didn't it? And now are you reducing the scope of your submission that it's just lot 302? Or still lot 300 as well? And at some stage, when the land is, whatever area of land is vested as reserve, council will have to go through another plan change to rezone it as natural open space.
It's not reducing the whole area. It is still maintaining that whole zone is rezoned to medium density. There are other areas within the subdivision that will be vested to council as reserve, which is currently zoned to be medium density residential. So that process might need to occur anyway if council want to rezone this as a reserve area. Also, as Ian noted earlier, it'll be, once it's vested to council as a reserve, it'll fall under the protections of the Reserved Act.
Yeah, but we're talking about the district plan here rather than the Reserves Act. What is the most appropriate zoning for these areas of land in terms of the subdivision consent that was granted? Presumably it went through a plan change. It was always part of the intention that there was going to be land in this area, lot 300 and lot 302, which were going to be vested as reserve, and then the district plan has proceeded on that basis. Sounds like it sounds like it's fairly well advanced, this particular entire subdivision. And I think the nub of the issue is that you might potentially want to do encroaching areas of earthworks to do the development platforms on the adjacent sites. Is that what it's all about? And you don't want to fall foul of natural open space protections, which are more stringent than the medium density residential, which would otherwise apply.
During the consent process, there's been a fair concentration on us identifying the areas where there's open space values and reducing the earthworks in those areas. So they may or may not reflect exactly on the ground the positions of those zones. What we're sort of saying is that the resource consent process and the processes and the outcomes will define the appropriate boundaries between the medium residential and the reserve. And I'm using the word reserve under the Reserves Act provisions rather than a zone. And because the earthworks have changed a lot over the period of time, because you've got situations where we've had to redesign earthworks because of, for example, unsuitable material being found, shortages coming in the overall thing, the boundaries of the actual lots and so on have changed relatively significantly over the course of the 7 or 8 years that I've been involved in the project. So we're sort of arguing that the appropriate mechanism here is not necessarily a district plan zone, but the Reserves Act to define the areas that will be managed for reserve, because that's what Reserve Act is for, rather than the district plan. And you've got a circumstance like where if it's in private ownership, it shouldn't be reserve or open space.
In terms of the district plan though, forgetting about the Reserves Act, the question is what is the appropriate zone for this area? And effectively your relief was that it becomes medium density residential when all of the subdivision which has preceded it is on the basis that it was going to be vested as a reserve. So that's why I started off by saying that this is very messy and may not, I ask my colleagues what their views are as well, it may not achieve the right certainty, and certainly it might require further changes to the district plan to accommodate this. If it is as a result of you needing to encroach on that area of land to do your earthworks, then Mr. Bellamy's advising us that there is sufficient capability within the natural open space zones under the earthworks provisions to provide for this.
But it isn't just the earthworks, it's also the use of the land subsequent to the completion of the subdivision. So where you've got a boundary position and say it alters, the position of the open space doesn't necessarily reflect the position of the open space values on the ground. So that's certainly the case, and that's demonstrated by 302, which council said, I don't want that because it doesn't have open space values. So you can't just say that because a district plan shows it as an open space there or that it has those particular areas. So the appropriate mechanism as such to recognise those open space values is actually the resource consent process, which we're undertaking already well ahead of the plan change. So that will establish the appropriate boundaries for the open space land, and that will happen probably before your decision is released. Then the boundaries of that particular land and the open space values will be protected through another process, which is the vesting of those reserves. So what I'm saying probably is that the district plan process isn't the important one in terms of protecting the actual outcomes, which is the placement of appropriate reserves.
We still have to determine what the appropriate zoning is of the land. And it seems to me to be a bit of a retrograde step to say, well, rezone it medium density when this land, or the majority of this land, is never going to be used for, or should not be used for medium density residential.
Yeah, I guess that's for you to decide. We've sort of put together our position, which is this provides flexibility to provide for the best outcome, which is ultimately what we focus on in terms of outcomes rather than the policy process.
So what stage is your resource? The resource consent is lodged. Have you had discussions with the council officers about what the outcome may be? Has there been requests for further information? Is there, where are we at in this process? Because it seems to me to be rather determinative to us in terms of what the appropriate zoning is.
The resource consent is split into two. One's focusing on earthworks, which is currently with council. It's under an RFI in relation to some stormwater aspects.
Yeah.
There have been minor RFIs about earthworks, but nothing in relation to its interaction with the natural open space.
Geotech.
Yeah, because it's been geotechnical RFIs. And then secondly, the subdivision consent, which creates the legal boundaries, is currently on hold until the earthworks consent is progressed.
So the subdivision consent wants what? For lot 300? Is it an amendment to the boundaries of lot 300?
Lot 300 is granted under a separate consent, and that will
Okay,
be
so this is all about lot 302, is it?
it's about the remainder of it, so the area to the west of 300.
Area to the west of 300.
Sorry, I don't have a,
Yeah, okay, so, because that is very much focused on 300.
so yeah.
But your submission was on the basis of rezoning lot 300 and lot 302, wasn't it? Or was it the area to the west, which is off that map there?
It was to the area of the west as well.
It was the entire amount. And so what is, we really want to understand what your position is. Is it for that entire area to have rezoned, to be rezoned medium density, or is it only part of it? Knowing that if the land is vested as a reserve, there's going to have to be another plan change to rezone it to what the most appropriate zone is for the land in question.
Well, lot 300 here can definitely, we agree that should remain natural open space.
Okay, so off, and the area to the left or the west of
That,
is a big area of land, isn't it?
There are areas of that where the boundary is defined, and that's, it's probably the areas, I think there's probably some explanation of where the boundaries are not defined at this stage would be appropriate information to be provided to the hearings committee.
I'm going to see if my colleagues got any questions here, because it sounds all very messy.
Read your submission, I thought you were basically just realigning that boundary between open space and residential. But it's a lot more complicated than that, isn't it? Yeah. So maybe a map, a plan showing the areas. Like I know we've seen the 300 and 302, but that's not the whole site. So if we could understand that and maybe and you know what you're intending, because it's just not quite clear.
but that kind of is the crux of the issue, is that map is not going to be defined until the legal boundaries are defined, and which is kind of the reverse process of what is going on here.
And that's exactly what Commissioner Day said. You're going to end up with another plan change to, realign those boundaries to whichever zone, so that they're not a split zone property.
But if the subdivision goes ahead, then it falls on each individual owner to rezone that small section of land from natural open space to medium density residential, which is
Well,
probably
potentially, or the developer could be upfront and do that.
true.
Yeah, it's not about who does it, it's about the fact that it would need to be done.
There's another potential method that I'm thinking about, if I'm understanding what your concern is correctly. What I'm hearing is you're concerned about the boundaries not being quite right between the two zones, and potentially some residential sites having bits of natural open space zone in it. Is that right? That's the crux of it?
There's potential for that to happen, yes.
All right, so a potential method that could address that, depending on the timing of your subdivision consent, is before this district plan is made operative, the council has the discretion to consider making minor amendments to the plan, which they would want to go away and look at that themselves, and it depends on the timing of your subdivision, and that could potentially incorporate minor tweaks to boundaries between zones to take into account subdivision. So it's a potential method that could be looked at, rather than rezoning the whole thing medium density. only to be rezoned later. Yeah, so that's potential method.
Yes, the subdivision consent, and as if probably still about a year away in terms of being granted, but we can definitely provide the most up-to-date, yeah, for this section here, to the most up-to-date boundary locations to council and yourselves to best replicate what is going to occur on the
So,
ground.
It's going to be a year. You've applied for a subdivision consent, which is potentially a year away from getting granted. Is that what you're saying?
It doesn't cover that particular zone. There's a subdivision consent covering other parts of the site at the moment. So
But it hasn't been sought as yet.
No, not in that particular zone there, down the bottom.
Okay. It's likely we're going to have some follow-up questions, certainly for the officers, about the relationship between the consenting process, what is actually happening with the reserve section of the council. We don't have any information. Mr. Bellamy's Section 42A report didn't go down to that level, and because you've got an extremely broad scope in your submission, which on the face of it is sort of goes in the face of what you're intending to do in terms of vesting land as a reserve. And now we're having to make a decision on the information that we have. And I think there might be a pathway. I don't know what that pathway is, but it is overly complicated at the moment.
Yes, we agree on that point. Certainly, having had 7 or 8 years of involvement in this site, it's probably the most complicated and difficult project I've ever been involved in by some measure.
Well, that's saying something for you, Mr. Leary.
Yes.
You usually take on the difficult ones.
Yes. So, but just in summary, in terms of this particular process, I think there are a couple of clear outcomes here that should be straightforward, which I would describe as laid out in Mazir sort of outcomes. One is lot 302 should be rezoned to medium density. I think that's probably the thing that sparked this whole process, because it's a classic example when something's wrongly zoned, the difficulties that creates. So, and then 300 should be open space. That's fairly straightforward. What we've just got to go through the process is the land to the west of lot 300 and how that is most appropriately dealt with under a district plan so that it allows for the protection of those those natural values that are present and the flexibility to go forward with the minimum of the minimum of issues with the district plan in future and how we administer that, both from the applicant, the potential purchasers and the council themselves in future.
Okay, that's all understood. I'm also very mindful of scope as well to do that, because it is quite a change from your original submission, what some of these possible options might be. But we will be issuing a minute at the end of this hearing requesting the officers, but it's likely we're going to be requesting some further information from you and your clients as well. As much certainty about your development intentions as it would be helpful. It would also be helpful if there was some correspondence with the council in terms of the land which they want to be vested as open space, to give the context for why the change of position is there. So we'll follow up with a minute, but we'll be likely to be putting you some questions around which we want answers so we can make the recommendation that we need to. Okay? Anything else? All right, well, thanks for your time.
Thank you.
Right. Now, can you hear me with that? Is that?
Yeah, if
Yeah.
you can make sure that the microphone is as close to you as possible, it helps out. It also depends on how loud people generally speak as well. Some people are quite soft, so the closer it is, the better for us to be able
Yeah,
to
the
hear.
acoustics in here are horrendous. Firstly, I appear on behalf of Winstone Aggregates. I've got Mr. Heffernan here, who you met earlier in the year online, Mr. Compton Moen and Mr. Hopkins. We've also got two witnesses who will be appearing via AVL. So they will, Mr. Herbert and potentially Mr. Exeter, but I just wanted to check whether the panel actually had any questions for him based on what
No,
Mr.
well,
Hunt
we
said this
we
morning.
don't, and you were here for our discussions with Mr. Hunt this morning. There is, sounds like there is absolute alignment. in
Isn't it a
between the-
lovely thing?
In between the two experts, so I feel we probably don't need to traverse those matters at all.
No, we have nothing more that we'd like to add on that either, sir. So we'll let him know that he's not required.
Yeah.
Now,
And your other gentleman online, he didn't produce evidence though, did he?
no, Mr. Herbert hasn't. He's actually just he's a geologist with Winstones, and he just had a few comments that he wanted to make verbally. He wasn't going to provide expert evidence, and it's under the 3 pages. So I hadn't seen that as that he needed to file anything.
But he is here as an expert though, isn't he?
As a company witness, sir.
As a company witness, but with a geological background.
Yes.
So he has expertise in geology, which you're wishing to put to us.
Yes, he was potentially going to tell the panel something about the aggregate resource in Area 3, which I thought might be of help, but...
Yeah, well, it is going to be of help because from what we've heard so far, a lot of this is all around Area 3.
But I'm in your hands as to whether you feel you can hear from him or
No,
not.
well, I'm relatively relaxed about it. But normally when we are having some technical evidence, you would have something written up so we knew who they were, what their qualifications and experience is in advance of them preparing
Yeah,
at the hearing.
I understand that, sir. My apologies for that.
And the other thing while we're on it, it was unusual to get rebuttal on rebuttal. We only received that yesterday, and for some of us, it was very late in the piece to be able to work out what was actually happening here.
Yeah.
And certainly we didn't realise until we received that how much alignment there was on the vibration matters. So I'll just leave that
Yeah,
there.
and just in terms of a little bit of understanding on why that happened, sir, because it is very unusual, and on Wednesday afternoon, Winstones received a response from the council, which was in excess of 50 pages with expert evidence that we hadn't seen before. Normally, in the usual course of things, Winstones and council had been talking about Area 3, you'll see, for about 3 years. So the officer's report didn't have any expert evidence in that, and it didn't become clear until we saw the officer's response that that was actually something that was hotly contended. So I did seek an extension to provide that evidence by
which we
5
gave
p.m.
you,
Friday, which I believe I met that deadline, sir, and I'm grateful of the extension. 'cause
Yeah,
it was a lot
I
of
think it
material.
might have come in very late in the day on Friday.
4:30, sir.
I
I was hoping that it would get to you, so.
Yeah, so look,
Yeah.
it is what it is, and I think we'll just box on.
Yeah, okay, we won't spend too much time worrying about it, but
Yeah.
we will try and take you through the material, bearing in mind that you haven't had a huge amount of time to consider it, so feel
Yeah.
free to ask any questions
Yeah,
as we go.
that would be helpful.
Yeah. So I have filed legal submissions. I'm going to keep these fairly brief just because it's a bit of a state of play. There are some key matters that I wanted to make, but then I think we'll hand over to the experts unless you've got any questions. So Winstones, as you know, is the owner and operator of the quarry. They're the only operator within the special purpose quarry zone. And there's been a tremendous amount of work done with the council to make sure that the new zone is fit for purpose and reflects modern quarrying practice and things like that. It is the last aggregate resource in the Hutt City. It's the last quarry that we have here. And the relief sought by Winstones is to ensure a continued supply of aggregate for the district. I've set out at 6 just some facts which I think are pertinent to your consideration of this issue, particularly when we're looking at balancing those amenity values versus access to aggregate in a quarry zone. Not going to take them through that, but I will leave them there. I've also set out the national direction. When the plan was notified, obviously there wasn't an NPS infrastructure, and that hasn't been taken into account in the Section 32 report. So I have set out the fact that quarrying is recognised as an infrastructure supporting activity in the NPS infrastructure, and I've set Policy 5 out for you there. In terms of Policy 5, it's probably important to take you to B1, and that's the direction that decision makers must recognise and provide for the role of infrastructure activities. And obviously that's a fairly directive wording in the NPS. Other policies in the NPS which Winstone say are directly relevant to your consideration are obviously the definitions of buffer and sensitive activities, Policy 10 and Policy 11. Also draw your attention to the fact that the quarrying updates to the NPS was also another matter that has come about since the plan was notified, and that was a framework that the government made changes to the NPSIB, NPSFM, NPSF across the spectrum to change the dial and the settings that are applicable to quarrying activities. Again, that's not something that has been taken into account, and it's not directly relevant to the district plan review, but it is something that just when we're talking about these wider things, you need to be aware of. In terms of the regional policy statement, I've set out the objectives there, and Commissioner Muspratt helpfully pointed out Policy 1 earlier, which is in my submission directly relevant to the panel's consideration of reverse sensitivity. And again at Policy 60B, the direction to protect significant mineral resources from incompatible or inappropriate land uses. And while it's not mapped, I think it's pretty fairly acknowledged that Belmont is a regional mineral resource. It's one of the last remaining quarries in this part of the region. In terms of the state of play, paragraph 13, I've set out there's a high degree of agreement in terms of where we've got to from the officer's response. We heard this morning there's agreement on the conservation activities. There's a recommendation to delete Quartz R4, which is supported by Winstones, and also a complete agreement on the vibration provisions. Remaining areas in dispute are the Quarry Amenity Protection Overlay, which is just limited to Area 3, and you'll see that that's a reduction in the relief that Winstones had sought in its original submission that sought that they were entirely deleted. There's the issue around maximum height of towers in Quartz Standard 1. The issue that you spoke about with the officer this morning around notification and activity status for noise-sensitive activities within the Quarry Protection Overlay. And I think it's probably a point of clarification. You asked the officer this morning whether, in relation to Quartz P7, whether there was disagreement and sought some reasons on that. From my understanding of Mr. Bellany's response, it appears that Mr. Hopkins and Mr. Bellany are aligned in that policy framework should only apply to the remaining Area 3. So I'm sure Mr. Hopkins will take you through that. In terms of the deletion from Area 3, you'll hear from Mr. Compton-Mohan. There's a disagreement between Mr. Compton-Mohan and Ms. Armstrong around whether or not removing Area 3 would have significant amenity, landscape or natural character effects that would warrant retaining that overlay in the plan. From Winstone's perspective, the Area 3 is redundant and it's not required to manage the effects. I think there's probably a submission there that because it's historically sat in the plan, it doesn't necessarily mean that it is fit for purpose or it should continue. So it will be for the panel to really consider whether it thinks that that protection is warranted when it's considering the costs and benefits of the various directions in those provisions. I think it's probably also fair to say that Winstones would like the panel to make a decision on whether Area 3 should be included or not, or what extent it is. And we would prefer that that wasn't something that was deferred and said, look, there's a consent pathway to do that, and you can apply for consent to remove that later if you have a problem with it. The reason for that is because it imposes a considerable cost and uncertainty on Winstones. It's a discretionary activity to remove it, and obviously there's a hotly contested situation here. Hearing Ms Armstrong this morning, it wouldn't be a straightforward thing for Winstones to remove that, particularly with sorts of arguments being made by council. It would be probably publicly notified, etc., and potentially appealed if we got there. So it's not just a solution to say, well, there's a consent pathway, what are you whinging about? You can sort that out later when we've got all the effects and everything on the table. So that's why, one of the reasons why we really tried to make sure that the panel had enough evidence before it, in this process, to be able to effectively consider that. Just moving to paragraph 19, I think it's probably fair to say that one of the reasons for the differing views is how the planners have interpreted the policy framework. Winstones say that Mr Bellany's placed too much weight on protecting what are localised values, and that they actually provide very little amenity protection. He hasn't balanced the costs of deleting them against status quo. And also, when you properly apply the the national direction and regional framework, you'd reach a very different view on that. Ms Armstrong and Mr Compton Moem have had a very fruitful discussion about the potential of a 10-metre buffer strip over the course of the break. I understand it's heading in the right direction, sir, but there's not total agreement. There may need to be, Ms Armstrong said there's a pathway to get there, but that we need to be able to provide a few more cross sections to be able to assess the visual screening capacity of a 10-metre buffer or a 20-metre buffer, and we've provided the panel with some visuals that have been helpful in advancing those discussions earlier this afternoon. So there's a pathway there, hopefully. I think there's also been some discussions on the height, and Mr Compton Moem will report back on that. In terms of the reverse sensitivity provisions, there's no disagreement that reverse sensitivity effects are something that need to be considered and dealt with by the plan in this area. The key areas of disagreement are around notification and non-complying activity status. And we were talking about this earlier as being a little bit of a two sides to each coin. You might not need both controls, but from Winstone's perspective, one of them is needed. We don't believe that the restricted discretionary activity status for noise-sensitive activities seeking to get consent in a quarry protection overlay is adequate, doesn't provide enough protection. And there's obviously those other examples in the plan where reverse...
I'll just wind back a little bit. Doesn't it depend on what the matters of discretion are? For it to be,
if you had...
the difference between fully discretionary and a pretty broad restricted discretionary with a number of different aspects of that discretion is restricted to, is probably not a whole lot. And that's not, but there is a big difference between non-complying and RDA.
I think non-complying gives a fairly strong signal to people in the plan that it's an incompatible activity. And my understanding is, it's not every activity that you're looking at. It's the noise-sensitive activities establishing in an area that's long been set aside as requiring protection.
But then again, it depends on the extent of mitigation that might be done.
One of my
Or
problems.
if it was at the very western edge of the overlay, as within the overlay, but as far as possible away from the quarry zone.
Yes.
Is that a fair response?
I think there's a couple of different responses in there, sir. And the first one would be, it depends on what the discretion is that's reserved. I disagree with the officer that trying to define the impacts on, it's the wrong way round. If you had it as a broad consideration of reverse sensitivity effects, then you're still dependent on an officer making that call based on probably looking outside and seeing a very static landscape of land that's been set aside for quarrying. And so inherent in that is who's making the decision about the effects and at what point in time and what do they know? And so I'd say there would only be very narrow times when, if you had non-complying activity status and you use the example of the western corner, maybe that's somewhere where you could say, well, it's so far away and the effects and you get through the gateway test there. But otherwise, I think, you're not going to know, and this is why these two things are connected. An officer's not going to know that unless they're actually seeking some information from the quarry operator about what their future plans are for the court zone. Because you could look outside tomorrow and find that it's all dug up and it's quite a different environment than when that decision was made.
Well, yeah. And presumably we'll be hearing from Winstone's experts in this regard. But there's probably, and I'm sure I'll be corrected if I'm wrong, there's probably already a reasonably well settled plan of attack for how you're going to actually manage the quarry over the rest of its remaining life. Which bits are going to be done first, so where potential overburden may go, those sorts of things are probably reasonably well known at this particular point.
That
And
might
again,
be a
I will be
question that you need
I
to
will
ask
be
them,
corrected if
sir.
I'm wrong.
Yeah, my understanding, and I've acted for Winstones for many years, has actually been that when you have these older quarries that have historically been quarried for a long time, things move around a little bit more than you would think, because it's not a matter of, you're going back and re-looking at areas where maybe in the 60s it was a good idea to put some overburden or something like that. So, but that's definitely a question you could have for Mr. Heffernan. I'll turn now to the MPS infrastructure and how implementation of the NPS. And I've just really set out for the panel there that both the Ministry of Environment guidance and national direction for the multiple instruments for quarrying and mining provisions needed to be implemented with immediate action to decision makers. And I've also set out the same guidance for the MPSI, where they require those things to be taken into account by decision makers such as yourselves, where there's an exemption to the plan making process. And I've set out the guidance in full for you there in the submissions. So unless you had any questions, those are my submissions for now. Might be best to spend the time hearing from the experts on some of those things.
Indeed. I'll just check with my colleagues. You got any questions of the legal submissions?
Ms. Tangott, I think I've got a couple of questions. The first one is about the MPSI, and the devil's in the detail in terms of defined terms. What the MPSI specifies what infrastructure is, what infrastructure activities are, infrastructure supporting activities, additional infrastructure, ancillary infrastructure activities, and those are all specifically used in provisions, right, policies. And some interrelate. You've got infrastructure and infrastructure supporting activities, which are essentially now the same thing. Oh, sorry, additional infrastructure, which are now essentially the same thing. But when you dive into the detail of where those defined terms are used in specific policies, and apply that to the definition where quarries falls under, are policies 10 and 11 actually relevant?
I'm only laughing because I had exactly the same question for Mr. Hopkins and did the same exercise as you, sir. I landed on the fact that I had two planners, one being the council and one being Mr. Hopkins, who both considered those and decided that they were relevant. I think you do need to look at, there's definitely policy 5 is relevant to the infrastructure activities. And then I think in order to give effect to those matters, I think you should consider policy 10 and 11. But it was a question that I had for the planners, and it is something that I guess the panel will need to grapple with. I did try to see whether there was any guidance for you on how this had been implemented elsewhere, because I think there is a little bit of a gap. Mr. Bellamy and Mr. Hopkins, not so much. But I couldn't actually find anything because it's so brand new. So if it's not a must implement, I think it's you should be aware of or very strongly aware of the general guidance provided in that document and I guess the tenor of those policies. The other thing that sprung to mind on that one was whether, that we've discussed, is whether it applies the infrastructure and the management in a wider way. And you look at policy 10, compatibility of infrastructure with other activities. And so you are kind of looking at whether it's infrastructure activities, those infrastructure supporting activities or not. But I totally take your point that those definitions don't squarely match.
Yeah, no, I think, yeah, I agree. It's something the panel's going to have to look at very carefully, and I think it's probably enough said
I
on that.
think probably as well, policy 1 that you pointed out from the RPS would do the heavy lifting if you did find that policy 10 and 11 weren't directly relevant there. They do sort of fill the gap in terms of the reverse sensitivity. So they're still providing that protection direction.
Yeah, I'm pretty familiar with the RPS in terms of quarrying. It's been there a long time.
The soil and minerals chapter goes back to 2013.
It goes back a long time, and it is very supportive. What it doesn't do is give you any detail about how to manage any effects. It's strongly supportive of the need for quarrying, and it needs to be close to the demand and all those things, which is...
But the council haven't implemented any of the methods.
So, but, it is well known. The fact we've got Belmont, and it is an existing quarry, and it does have a relatively significant proportion of the aggregate supply in the Wellington region comes out of it as well, is well known to everybody. And has had an extraction zone provisions in the HUT plan before, and has, from all accounts, been working reasonably well. So, yeah, we understand that side of the argument.
Fantastic. Were there any more questions?
I just have one more. It's to do with, it's regarding sort of around paragraph 12 of your legal submissions regarding the RPS direction. So obviously the district plan has to give effect to the RPS. Then the RPS itself specifies which provisions must be given effect to and which provisions must be considered by decision makers or had particular regard to. Do you know whether policy 60 is one that must be given effect to, or whether it must have particular regard given to it? And apologies, this may be a better question for Mr. Hopkins.
I can double check that while everyone else is giving their evidence and come back to you with the answer.
Thank you.
So, yes, thank you. So I just, a couple of little questions from me, just for clarity. So your paragraph 17, at clause D, you say that area 3 has long been set aside for quarrying. That's not really my understanding of area 3. My understanding of area 3 is it provides a visual barrier to the quarrying, to the quarry. So I need to understand what you're meaning there.
I think in terms of, going back many, many years, and the quarry space has sat there for 100 years or so. And so that area has been in the extraction zone for a really long time. So it sits within the zone, but then there's an overlay. I take your point that the overlay sits over the top and provides, I mean, I think it's important to note that the overlay doesn't provide absolute protection in the operative plan or the proposed plan. So it's still a discretionary activity there, but I meant that the land has been generally zoned and sat in the quarry zone for a long time.
Thank you. And just another clarification regarding a sort of implementation, transitional arrangements for the NPSI. At para 46, you say that it requires immediate action, and that you say it must be implemented from its commencement date of 15 January. Is that the case?
Yes.
So in this situation where the plan was notified and submissions were received prior to the NPS being notified, how would it be possible for this process to implement it immediately when it's I mean, you yourself know the Schedule 1 process of submissions and things like that. So how would that even be possible in this situation?
Well, as I go on to explain a couple of things, Winstones did actually seek that there was, that the district plan was aligned with all national direction and new national direction that was incoming as part of its general relief on its submission. But secondly, if you go through and look at paragraph 48, it specifically deals with a situation where ministerial exemptions have been granted to proceed with planning processes. And I think that's the situation that you're in. And so the guidance there, or the explanatory note to the NPS is saying plans won't be updated to give effect to the national policy statement unless a relevant exemption applies. And as I read that, we're in a situation where the council's received an exemption, and that it is that's where the rubber hits the road with those immediate commencement directions. And I've set out some case law around this in the Hawke's Bay case referred to at paragraph 49. That's a situation where the court was examining an appeal, and it said, look, if there's a NPS that's got a direction with an immediate commencement date, that's going to have a bearing on what you're doing. And in that case, there definitely wasn't NPS direction that existed at the time that the council hearing started. But by the time it got to the appeal, it was something that the court found was a relevant thing. It is tricky, and you will hear slightly different advice, and I know that council's received different views on this from council. And one of the reasons for that different view is because it depends on the NPS that you're implementing and exactly what that says and what you've got in front of you, and then if there's scope and what you're looking at. So there's not a clear rule of yes or no, but what I'm saying here is that in the NPSI, it is in that basket where there's a direction for immediate commencement. The national direction is providing a really strong indication to the panel in this case, in this situation, that does apply. And you've got a quarry zone that you're looking at where, those provisions are, or that policy guidance is fairly helpful.
Yeah, I struggle with that just because, submissions had come in on the notified plan prior to the NPS being, made available. So it meant that the General Joe Bloggs was not able to make a submission on those new or altered provisions, along with Winston's couldn't make a submission on those. So, you know, it's not a fair process. So, and I think you must agree with that.
I
The
do.
other comment I'd just like to make is, you know, you do refer to that case here. I mean, what was that case about? Was that a plan process, or was it a resource consent?
It was a plan change.
Plan
I've
change.
actually set out the details of that in paragraph 44, bullet point 2. So you've got a little bit of a description, but I'm very happy to provide you with a copy of the case if that would assist. In terms of whether or not people were notified of the council's intention and had a right to make a submission on the plan on this, I think that's not necessarily an absolute thing, because the national direction actually does cut across that. And you'll see many examples where the government is requiring councils to change or implement their plans, sometimes without going through the Schedule 1 process as well. So the devil's in the detail on what the NPS direction is saying in a particular case. And so I would say, well, my take on the NPSI in particular is that it's something that the panel does need to implement.
Thank you, that's all I had.
No, I think we had this discussion before, and you have looked at Mr. Quinn's advice upon this whole issue about new national policy statements in the stage that we're at. I'm taking it that from his advice that we need to act with a fair degree of caution, looking at the submissions and looking at what the NPSI sees. In the case of Winstones, though, you do have an existing quarry, you do have an existing ODP for the quarry. It's about what is the most appropriate
Yes.
makeup of the quarry zone itself, rather than arguing potentially about whether or not the NPSI is.
It's helpful, sir, but it's not, you know, if you decided that you weren't going to consider it, I think, again, in the RPS, there's sufficient policy support there. However, you know, MPSI is there and very helpful.
All right, okay. I've got no further questions, so we'll proceed with your witnesses in order, presumably. With Mr. Heffernan first.
Thank you, Chair. Based on the conversation, I'll just jump to some of the areas around Amenity Area 3. Obviously, everyone's pretty aware of where we are, who we are, and what we're doing, and tomorrow I'll be your host up at the quarry to show you on the ground. So the why around Amenity Area 3, it really comes down to there's about 3.3 million tonnes that could be quarried out of that area. To put it in perspective, that's about 4 to 5 years worth of resource. Now, I'll get Paul, Mr. Herbert, to jump in a second. But it's not only that, because the way quarries work, and it'll cover the Chair's question around which way do you go. You've got to make those quarry decisions. We've got quarry designs. But we would be able to have a more efficient quarry if we were able to get in there. We might be able to add 10 to 15 years to that, the resource. And what we look to do with a brownfield site is maximise it. It states the obvious. Quarries are big, they're hard to consent. We have done some, but we do them pretty rarely because it does take a long time. Circa 10 years consenting, $150 to $300 million to do it, and then you've only got dollars coming out at the end of that. So in short term, we won't be consenting a new quarry in the Wellington area, and probably maybe some of our lifetime. Belmont's going to be it. Mr. Herbert, do you want to just jump in and talk about that Area 3 and the reasons around that?
Yeah, sorry, just quickly responding to the Chair's question earlier. Paul, could you introduce yourself and just give the panel, obviously, what your job description is at Winstones and what your qualifications are, please? Oh, we can't hear you.
Sure, just making sure everyone can hear me okay?
Yes.
Good. Good afternoon, panel. Yeah, my name's Paul Herbert. I work with Winstone Aggregates. My background is as a geologist and an engineer, working in the extractors industry. I've got about 20 years experience working across different sites throughout New Zealand, across extractives. So in relation to our conversation today, specifically Area 3, this area is of interest to us. There's a significant resource within that area, as Mr. Heffernan has pointed out, about 3.3 million tonnes, representing 4 to 5 years of production. And that has a broader picture to tell. So that's immediately within that area. If we're able to access that area, it unlocks further value through optimization of the quarry design, and has potential to unlock another 10 to 15 million tonnes of resource. And that represents significant value for the site. In terms of what we know about the geology, specifically in Area 3, just I guess at a high level, first of all, why is the quarry there in the first place? There's a number of reasons for that, but the most fundamental reason is because the quality of the resource that exists there. So the resource is a Greywacke resource, and Greywacke has basically two components. There's an argillite, which is a fine-grained material, and then a sandstone, which is a coarse material and represents a higher value resource. We're able to make higher value products from that resource. The area specifically in Area 3 is a large proportion of the sandy type of Greywacke. We're able to make premium product from that resource. We're able to make products suitable for road chip sealing, and directly in concrete manufacturing as well. And not all quarry resources, particularly in the Wellington region, are able to meet the criteria for those specific premium value products. We do know a reasonable amount about the geology in Area 3. We've done a series of drill holes. There's about 6 specifically in and around that area. And we've drilled down to a depth of over 100 metres below the current quarry floor, as well as doing about 2.1 kilometres of surface mapping. So we've got really high confidence in the quality of that resource, and that it's currently, operationally, it's been the area adjacent to Area 3 is our go-to spot for producing high-quality aggregate. In terms of its value, the way quarrying works is, as I know you're familiar, we generally can expand laterally, or we can expand downwards. As the site is quite constrained already, there's not a lot of opportunity to expand laterally, and that means we need to develop the quarry floor. As we do that, we start to reduce the opportunities for lateral expansion in some areas. And this Area 3, we've developed high wall crests, so we've expanded laterally as far as we physically can at this point without encroaching into Area 3. As we form up those faces and develop the quarry floor, there will be a point in time where we actually sterilise that resource or part of that resource in Area 3 by cutting off access to it and make a constraint. So really having access to the resource within Area 3 represents significant value for the site and unlocks additional future value.
Thank you for that. I don't have any particular questions, but it might be quite useful for us if you were to put that in writing, and you know, it was because when I came in here today, I was expecting to actually ask some questions about how you're going to attack this. What's your plan? What sort of quantities are you looking at? Why is it so necessary from an economic or longevity view for the quarry that Area 3 was so important, and you've been able to fill in those gaps, or to some extent anyway. So thank you for that. Now, Mr. Heffernan, had you finished, or were you just handing over and coming back, or? terms of-
Please, the Chair, I'll just continue. I've only got a little bit more. I
Sure.
was just conscious Mr. Herbert actually had a previous appointment, and I know Paul will be too polite to be leaving a hearing short, so thanks, Paul. Just the last couple of points I wanted to make. One, there was Paul covered a little bit of the design, and we'll see better out on site tomorrow some of the choices a quarry makes over its lifetime, and we'll see some areas which we have gone into, which we are currently quarrying, and there is some limited overburden and something that we call fines above, and that'll just show you the challenges a quarry has. I always think of it's like a Rubik's Cube. Every decision you make has a paradox decision, and you're probably kicking that down the line 20 or 30 years. So some of these decisions are quite important, like Area 3 on how we roll out the quarry. The other one is around Mr. Hancock's comment earlier about a consenting pathway into Area 3. Consenting pathways, I've consented hundreds, if not thousands of consents. They're all doable, consent in time. It's the unknown factor from a business point of view that I'll put forward, and then the potential risks of notification and then going down that, which I know all the commissioners will be well aware of. And that just creates a lot of uncertainty for a business like us. And what that leads to is effectively we don't invest as much if we don't have the time frames. We need to look in our quarry business 20, 30, 40 years when we're investing equipment. Belmont, if we get some of the zoning requirements we're asking today, but also our fast track, we'll put circa 30 million back into Belmont. At the moment, Belmont doesn't have that life expectancy to put that into. We just wouldn't be able to get the returns on that. So we haven't done that. When we're up there tomorrow, you'll see how old some of the equipment is, because Belmont has kind of been on a 5 to 10 year track because of some of the constraints on site. My last point would be just also around some of the reverse sensitivity, and we do around our quarry portfolio, we have 12 around the country. We do often have houses pop up in areas which are in different zoning areas, depending which area you're in, saying, oh, that's a quarry buffer area of that. We currently have one in our Whangaripo quarry, which I have in my evidence, around which is a joint venture with Fulton Hogan, where a house has been built in the last 10 years, and now they're actively against the quarry in some of the consents that we're doing, which is what I'd call as our business as usual consents. There's no massive expansion. There's no big other things we're doing there. It's kind of just renewal of a number of consents we do have up there. But that house is actively submitting against and contacting council, and it's within a buffer area. So these buffer areas are, even when they're there, we have had issues in that spot where a landowner builds a beautiful house and then they look at a quarry, the quarry's changing, and they're like, we thought we were going to look out on this view and the noise and different things, and it wasn't going to change. It's a dynamic environment, and quarries do change, as we'll see there tomorrow. So those are all my main points, but happy to take questions from the panel.
Thank you, Mr. Heffernan. To my right.
Yeah, I did have a couple of small questions. In relation to, you just talked then about replacement of structures, reaching the end of their life. Is that your focus on height? Are these the structures that you're wanting to replace? Is this why the height constraints are there?
Correct. So at the moment, I'm trying to think ahead from a business point of view. What would we put up there, and what restrictions to make sure we effectively replace? I mean, there's existing use rights, but some of these will be different type of kit or more modern kit. The kit up there that we use in the plant, which is things like we're crushing the rocks, etc., are probably 30 to 40 years old, some of them. So the equipment we'd currently use would be quite different, and depends who I talk to in the business. There'll be some of them will be taller, fatter, different, there'll be cost implications. But those are the ones I'm trying to work through with the wider team here. What would we put up there? Where would we put it on site? Again, also that Area 3 would be crucial, because if we didn't get Area 3, for example, a pathway we thought was acceptable, we'd be restricted where we could put it on site. And so we might have to put it somewhere else, and that might be a different piece of equipment, because we'd have limited areas to put it. The site is, while it looks quite big, is quite constrained, particularly the area they call the stockyard and all the processing areas. So again, the Area 3 would be quite crucial to do what I think of as master planning on where would you put it, where's the best spot. I always say with the quarrying industry, it's a transport business really. It's about trying to be efficient about getting the rock out. if you can be more efficient, you're just going to be able to get a cheaper rock out there, and it's essential to all the infrastructures everyone knows about. So that, again, even on-site will be a key thing of where do you put it close enough to the rock that you're getting to process it. So all those things would come into play. But the quick answer is yes, that's some of the consideration we're thinking of.
And not all of the equipment would have to be at the rock face, would it?
No, that's-
Like, I mean, there's quite a few structures listed. I'm assuming that they all belong in the same spot. They could be spread out over the quarry floor.
Correct, but it does depend, again, some of the efficiencies, and also, again, I'm trying to second guess what type of equipment we do and how we'd roll it out. Because a lot of, so if we're in somewhere like Germany, we'd automate a lot more. New Zealand still chucks the person in the machinery a lot more than overseas does. But that equipment might, I say 30 million, that might be 100 million, which we're probably not going to be able to do. So we try to look how to, from a health and safety, but also efficiency, where do you do it? And you still need to try to look at, okay, crush it there, but then you need to take it over. We have sister business units on site like Firth, and we have an asphalt plant that's owned by Fulton Hogan. So it's trying to work out how you get it safely to those areas as well and make it a shorter distance. So trying to take all those things into account and what kit works together. And it also could be the rollout of that equipment. I say 30 million, but that could be over about 5 years. That's a lot of equipment to put up there day one. So you're probably going to stage it. And how does that work? Again, it's a master planning similar to how you'd roll out a city centre or a residential.
Sure. Just the other question I had was around notification. And you mentioned other quarries that Winstone have. What's the process there for if an activity was to happen?
So at this point in time, I don't know of any that have where we get notified. At the moment, the best I think we have is we do have good relationships with a lot of the councils. We're known quantity, so we do get informed, but that's informal often, not actually something in the plan that I'm aware of in any of our quarries.
Yeah, sure. Thank you. That's all I had.
Thank you. I just have one question. It relates to paragraph 7.6 of your corporate evidence. We refer to a list of development types that might not be known to council in a consent process. The panel doesn't have a copy of any quarry management plan. So my question is, are those sorts of things go into a quarry management plan in terms of future development aspirations and sites and transport routes and those sorts of things? Or is it, like, how does the quarry management plan,
So
what level of information is in there regarding those things?
Yeah, so it does to a certain extent. The quarry management plan is probably circa about 150 pages. It's a lot of the management plans you would all normally expect. It does have some of the quarry pit designs in there, so saying which area we're going to go to. And it does have some limited amount of the haul roads. But it is quite dynamic. Mr. Herbert covered a little bit of it, but some of the areas, effectively, we do drill, we do know what the rock is, but some of the rock isn't always what we think. So often it does change when you're out on site. And the quarriers themselves, they call things like, and when we're on site, some of them may refer to it, green rock or blue rock. To me, it all looks like rock, to be honest, a greyish look to it. But there's certain types that are needed for certain products. So even though some of those are in the management plan and the effects are well constrained around that, some of those rollouts are a little bit different than it actually does look in the design. Not like, say, where you roll out a residential and you've really got to do it in that certain way. A quarry pit has got to be dynamic and it's got to look at the products. So the other ones are clearly, Mr. Herbert again touched on some of the good rock that you can use for things like concrete, but you actually do sometimes want some of the bad rock because you may want it as base course or other things. So an NZTA might come to us building a big road, but they need to put the poorer rock, shall we say the browner rock and other things down first. So not all rock's the same. And that relates back to the quarry management plan. It's got to be dynamic to fit that in. So why areas of that are in there, it's not always fixed on how that works.
We're obviously going to go up and have a look tomorrow, which will be good. Hopefully the weather is kind to us. And it will be quite helpful to work out, what you've got and where you might want to go in terms of structures. Yep. Probably worked out from some of my questioning this morning that standard S1 is pretty permissive. And I would like to have an understanding about what current plant you have and what your expectations are, particularly below RL 45, and where such plant over 24 metres in height might go, and for what reason. So you can think about that and perhaps explain it to us on site, or you can explain it now. Similarly, for those areas above RL 45, is there any intention or expectation that major pieces of plant will permanently be located in those areas? Is it a possibility? And if so, what sort of plant would need to go? Because my experience with quarries is that there's generally most of the time there is a fixed location for the plant, and the aggregates gets brought to the plant and gets crushed and cleaned and then transported off to the site from that location. Whereas the areas which are remote from that particular area of plant the rock is extracted and brought to the plant itself. So I'd be interested in that. And I did ask the question, and it has been, I've been looking at this there. It's a major escarpment on the hillside. What's the end plan once quarrying is completed and Belmont is exhausted, whatever time that might be? What's that going to look like? I'd also like to know where RL 45 is on this, because that is reasonably significant in terms of where when Area 3 comes into play. So we'll have Mr. Compton-Mohan at some stage, but they're the things which are going through my mind. You can either answer them now if you know them, or we can get that information another time.
Thank you, Chair. The first question, I think, out on site, particularly where we look to locate some of the plant, because we'll be able to see some of it. As you point out, it's probably going to be very similar to it. In my mind, it might be in different spots, but be plus or minus a few hundred metres from where it currently is. There's only certain locations, the way the pit rolls out. Above 45, I will check internally. I don't think there are any proposed of what the equipment I'm thinking is going to punch well above that, but I'll double check that with some of our design team. And the end-of-life plan, I'll check where that is. I haven't seen an end-of-life plan for the quarry. To be honest, I've probably been focusing trying to keep it going at this point over the last few years. But we do different things with different quarries. I have the luxury of once living in one of our ex-quarries up in Auckland, a Larnav quarry that has now been turned into residential. Belmont won't be one of those, but a fill site, normally clean or managed fill, would be its likely end of life. But I'd suggest that would be 40 to 60 years before we'd look to do that. Effectively, as Mr. Herbert covered, the rock itself goes quite far down. So it's how that would be played out. We would be sterilising the rock if we probably shut it anywhere between 40 years. So as I covered in my evidence, this will probably be one of the last quarries in what I think is the Wellington area. You'd be going out and quite far before you get another quarry of our size. So whether it's us or another owner in the future, we'll be trying to maximise that resource as much as we can.
Yeah, from what I'm aware, that there is still a little bit of prospecting occurring, which is natural. How far that goes, I wouldn't have a clue, but certainly it has been raised that unless there is a new resource found, then the existing quarries have only got a certain shelf life. So that is pretty well known. I think there was quite a authoritative report done a few years ago on aggregate demand and supply and where it's going to come from in the future, because I wouldn't say we're at a crisis point, but there's no plan B at the moment.
That's correct. It's the Infrastructure Commission circa about 4 years ago.
Yeah, that'd be right.
Yeah.
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 But I think there was something even before that too, so.
Yeah. And to put it in perspective, I think circa the 70s, there was about 30 quarries. Now, they wouldn't all be Belmont size, but there would have been a number of quarries, and now we're down to us and Horokiwi, and there's a Willowbank over the back, but its production at the moment, I believe, is pretty limited compared to us and Horokiwi.
Yeah, and Kerry Point is the one that I've been involved in, has also got a area consented, but I don't know whether that's going to happen or...
My last knowledge is about a year ago, they were looking for an operator to try and
Yeah.
come in, but I
Yeah,
haven't
that
heard
was
anything else.
probably when I left it 5 or 6 years ago. Okay, thank you for that. And in terms of arrangements for tomorrow, you've given us instructions. We need safety boots and stuff like that. So
Correct. Safety boots, long sleeves, long pants, and that's the main thing. We can provide the rest.
Okay.
Then we'll go around the site.
all good. All right.
Excellent.
So yeah, 9:30 will be good.
9:30 car park, not a problem.
All right, Ms. Tancock, back to you.
I'll just hand over to Mr. Compton-Moen. And I understand you've now got your visuals in front of you, which will hopefully assist describing where we've got to there.
Perfect. Afternoon, Chair, Commissioners. My name's Dave Compton-Moen. I'm a landscape architect and urban designer. Can I read through my executive summary in my rebuttal evidence? Is that the best place to?
Yes, it is, and I certainly read it. I think the others have as well, but it's pretty new information. Some of that too, particularly where there's been a response to Ms. Armstrong.
Yes. Yep.
Okay.
So I'll start at paragraph 3.1. I agree with Ms. Armstrong that Te Awa, Kairangi, Hutt River and its recreational out corridor are relevant landscape considerations, and that Area 3 presently provides some local screening and green edge, and that the skyline protection is appropriate. I do not agree that Area 3 has been demonstrated to be an outstanding natural feature or landscape, or that it is a defining or indispensable component of an outstanding natural landscape. The quarry amenity protection overlay is an amenity and vegetation control carried forward from the operative plan, but is not an O&L identification. I do not agree with Ms. Armstrong's preliminary moderate high effects ratings. Those ratings do not adequately distinguish between the substantial physical change that would occur within Area 3 itself and the effect of that change on the values of the much wider river corridor and western escarpment landscape. Here, natural character components expressly address perceptual matters only, without a full natural character assessment or natural science information, and her wider landscape and visual conclusions are high level and rely in part on the assumptions about quarry staging and methodology. Area 3 is a relatively small, peripheral and already modified component of a much wider western escarpment. It is embedded within and visually read as part of an established quarry and infrastructure setting containing a long established quarry, exposed faces and plant, the Western Hutt Road, the rail corridor, flood protection, recreation infrastructure, urban development, electricity transmission infrastructure, and the Hayward substation complex. These elements do not remove natural values, but they materially influence landscape sensitivity and mean the change would be perceived as an incremental extension of an existing activity rather than a new isolated intrusion. The proposed 10-metre strip, and so we've now got some visuals which I'll take you through in a minute, is a retained landscape strip. I think the potential was some confusion before whether it was a new element, but it'll be retaining the existing topography and existing vegetation which would remain in situ, with supplementary planting added to strengthen the edge. It's not intended that the strip be excavated, flattened or removed and then replanted. I support a landscape plan including surveyed topography, retained vegetation and supplementary planting being incorporated into the quarry management plan. I also support recessive low reflectivity colours and a fixed maximum top of structure RL to be confirmed by surveys so that specified structures do not pierce the skyline and views from across the river. And since post Ms. Armstrong's presentations this morning, we met together and looked specifically at the 10-metre landscape strip through the front. I think we're both in agreement that it sort of needs to be a nuanced approach, that cross sections through that face would be beneficial. If I take you to the first visual that I've got, it's interesting in that the quarry boundary isn't on the road boundary. It varies along that length, and it's up to, in places, almost up to 20 metres higher than the road. So the road's sort of like at roughly about RL 28, 30, and then there's the boundary in places is up to RL 50. The boundary, the Area 3 boundary is then subsequently 4 or 5 metres within that boundary, and it's noticeable that in a short distance of 4 metres, the topography climbs another 7 metres. So it is steep through there. It's well vegetated. So if we were to have a 10-metre retained strip that's vegetated, we're sort of taking the top part of that screening to about RL. I just wrote it down before, to about 70 RL. Now the top of Area 3 at the moment, if right at the back of it, the RL there is about 93, to put that into context.
Thank you for that. Sorry, it's been a bit of a bugbear of mine about wanting to know where the cut-off is between, in standard S1, and between the 12 metres and the, and...
So for RL 45?
Yeah, so you're saying that RL 45 is well below where your 10-metre buffer is?
In places, the 10-metre buffer does come down and up. So towards the northern end of it, it actually does come down to almost at road level. But in the middle of Area 3, it's up almost 20 metres.
Okay. I'll just hand over to my colleagues.
So I think what we're both in agreement that obviously more of the quarry will be visible with the partial removal of Area 3. It's just that degree of those effects from those changes. Ms Armstrong was more aligned with potentially pushing that line back to 20 metres from the boundary. So therefore then that increases, and that typically takes us probably up to 75 RL in terms of the amount of screening that we're providing.
Okay.
Yeah, and so behind that first page you've got...
Yeah, it might be helpful if you walked us through these. At this scale, it's really hard for me, well, me anyway, to read your notes on them.
Yeah, sorry. These images are, they haven't been modelled. I did have the advantage of having a cross-section provided by Windstones, and they do have the area modelled, and they regularly map it for extraction because they measure it, and so we can actually develop some quite detailed cross-sections. The first page basically just highlights the on the left-hand labels, highlights the top of Area 3, being at roughly 93 RL, and then there's a series of steps coming down, just really to show that we're not talking about a 10-metre height vertically into the site. Really, it's a 10-metre or 20-metre distance horizontally into the site, but actually the height difference is much greater. So on the third page, I've got a mock-up here of what potentially it would look like with Area 3 removed and the 10-metre retained stripped.
And
then
that's standing next to the river, isn't it? So it's quite a low
so yeah, it's on the
that you're looking from that,
yeah, it's from the stock bank across the road from just by Taita Drive.
yeah.
Yeah.
So did you, oh, well, no, I don't think you have. You haven't done any sort of further afield, higher elevation looks across to see what that would look like?
Yeah, so it's probably getting more similar to that first page where, you know, the Google Earth image
Yeah.
will appear.
I mean, that's we're a bird in the sky on that one though, aren't we?
Yeah, yeah. And so as we go higher up, obviously more of the quarry will become visible. And obviously the greatest effects are going to happen between from RL 93 downwards, down to wherever we land in terms of that that strip along the front.
Yeah.
That's where the greatest degree of change, I think, will occur. But then we also benefit from having distance, and at that same point, more of the quarry is actually visible at the moment. So it's, when you walk around the area, there are areas where Area 3 provides substantial screening, but quite often they're quite limited. You can move 50 metres along the road and then the quarry, which goes up to the skyline, is visible again. So
Sure, and you made that point earlier as well when you said structures, you know, in some parts won't be visible over that 10-metre line, but in other areas they would be very visible. Yeah,
Yep.
I understand that.
Yep. So I think in terms of structures and looking at it's been a bit of a moving target but the intention is to not have structures piercing the skyline when you're looking at it from different viewpoints. And it will be interesting tomorrow, you probably have the information, you know, where that RL 45 actually is. It's quite low down on the site. So potentially at the moment, under the current framework, you could put a 12-metre structure up substantially higher. It could be on RL 100, you know, it could be quite high on the skyline. I think what we're trying to do is provide Winstones with greater certainty that they could potentially, say, put a 30-metre structure, whatever they need for their quarrying activities, on the quarry floor. But as long as it's not going through, you know, RL 80 or RL 70, it's not actually going to have an effect on the skyline.
Depending on your viewing platform.
Yes, yep.
Yeah.
Very difficult to tell the difference in this plan of the difference between 10 metres retained landscape strip and 20.
Yes, yeah.
It's just two red things, just
I
arrows pointing down.
We can do some new plans, and I think, and some new cross sections to go with that. I think they'll be actually the best tool and method to help with your assessment of effects.
And you're quite happy to continue conversations with Ms. Armstrong?
Yes, yeah.
Okay, and I think she expressed a willingness this morning. I don't know whether we will formally request conferencing, but we will request you to confer. Okay. Any further questions? Matt?
Yes, Mr. Compton-Moen. If I could take you to paragraph 6.2 of, this is your, this is the rebuttal we received yesterday, where you state, and this is where you address section 6A of the RMA. You state that whether the more elevated quarry land falls within the statutory margin of the Hutt River is a planning and legal question. What do you mean by that?
Sorry, again, it was paragraph 6.2?
Yeah, second to last sentence there.
Okay. I think my opinion, and give me a bit of thought this morning, is that this area isn't a, it's not an outstanding natural landscape. It isn't a section 6 matter. But I don't know the process that the council's gone through with looking at the outstanding natural landscapes and whether those are mapped. But my understanding is that this area isn't. And I think although it's close to the river corridor, and some views it's viewed in context with the river, I don't think I don't think that it extends that far to incorporate this site, particularly given that the existing context of the quarry.
Right. So I asked Ms. Armstrong this morning whether she considered that part, Area 3, to form part of the margin of the Hutt River under Section 6A of the Act, not Section 6B, which is the outstanding natural landscape part. She was of the view that it was part of the margin based on her assessment. So what's your view? It is part of the margin or not part of the margin under Section 6A of the Act, not Section 6B?
Yeah. No, I don't think it is. I think there's enough's the wrong word, but there's a lot of intervening development in the area that provides enough of a physical and visual break between the river and the site.
Okay. But you agree it would be at least the job of like a landscape expert, at least a landscape expert, to determine that, not a planner and a lawyer, to carry out that evaluative assessment and determine if it is a river, part of the margin of the river?
Yes, potentially. I wouldn't have thought it was necessary on this proposal. I think at the very beginning of my assessment, it was very much focused on the visual amenity aspects, and the its visual importance and special amenity values, and so that was the key driver for my assessment. So landscape architects obviously are involved in that determination, but that's usually, I wouldn't have thought it was necessary on this proposal. It probably doesn't quite answer your question, but
So you have answered my question. I was just after your opinion. So thank you.
I don't have any particular questions. I think this is still a little bit of a moving feast for us. In our minutes, requesting the officers to consider further information, we'll also be requesting some material from you, Mr. Compton-Bowen. We'll need to formulate what that is. I think it's going to be very helpful to go to the site and to also look at the site from different perspectives as well. So, yeah, thank you for your evidence.
Thank you.
Mr. Hancock, we have Mr. Hopkins, is it?
We do. Are you happy to continue, or did you want to take the afternoon?
I was looking. Yeah. What do you think? Should we push on or? Yeah. Look, can we have 10 minutes? And
Of
that
course.
would be really good, actually. Thank you. We'll recommence now. Mr Hopkins, presume you're going to be taking us through the exec summary of your rebuttal. Is that the most effective thing to do? Or
Yes.
what would you, I'm in your hands, but
I was going to make the same offer to you, Chair, that I'm in your hands. I've got I can give you a quick summary and then we can turn to that in terms of the matters that are still in dispute.
Yep.
If that's most helpful. So thank you. I'm Colin Hopkins. So I'm an independent planning consultant for DCS. So as you would have seen across both pieces of evidence, in general, there's a broad agreement with the council in that the quarry zone provides for both enabling and managing the effects of quarries. So in my primary evidence, it confirms the matters of agreement, which also includes matters where I have reviewed the original submissions made by Winstone Aggregates and considered the council's recommendations and where I agree with the council. In terms of the matters that remain in dispute, if you turn to my rebuttal evidence, and we start at 2.1, that lists the matters that remain in dispute with the council, although as identified by Ms Tancock, in terms of the cause policy 7, there is some alignment with Mr Bellamy as discussed earlier this morning. So in terms of those items, I guess that's where I kind of fall into your hands. Would you like me to address each one or would you like to just direct questions?
I think you should address each one. That will be helpful.
So the first one is with respect to the quarry zone protection overlay. And there's the two matters that are reflected in that, which is to do with the notification provisions and whether a directive notification provision should be applied for the activity, for which is my view that there should be one. And in my evidence, I've given you some options to consider. Further to those, and just picking up on a question that you had to Mr Heffernan in terms of an example, one example that I do have for you, which relates to the way overlays for reverse sensitivity effects are managed in the Auckland Unitary Plan, is they include a notification provision which directs you to consider specific parties. And in that, and I can give you the reference we provide in writing, it says when deciding whether any person is affected in relation to the activity, and then it has a series of clauses because it covers a number of overlays. But it says in relation to an overlay to manage reverse sensitivity effects, the operator of the activity which is protected by the overlay from such effects. And in my view, that provides, when you have a directive notification provision like that, it provides a clear indication to the processing officer about whom you are considering the effects upon and what the scope of those effects could be. The other matter there is the appropriate status for an activity. It's my view that a non-complying activity status for sensitive activities in the quarry zone protection overlay would be an appropriate planning response to managing those activities. They are there. The overlay is there to protect the quarry, and it is the future enabled effects of the quarry that need to be considered too. And in my view, a non-compliant activity reflects that that those activities aren't anticipated in that area, and that there are known effects of the quarry that can be experienced. I think it's also fair to say that when you look at, because I think your questions were around comparing, would a restricted discretionary activity be acceptable? I think the issue there is that over time, when planners review restricted discretionary activities, they tend to view, because they've been stated and considered such, that they are somewhat provided for, whereas a non-compliant activity would set that clear indication for consideration.
Doesn't it also depend on the strength of the objectives and policies that apply as well? The wording of those?
Yes.
Okay, leading back to the matters of discretion and the reasons why they are matters of discretion, how strongly worded the objectives and policies are?
Yes. And I suppose on those matters of discretion, in my rebuttal evidence, Mr Bellamy had, I think, helpfully attempted to include an expansion on those matters for discretion. I've suggested that they wouldn't be required. I mean, I think reverse sensitivity should be well understood. But my suggestion there to include that if you were of a mind to consider that restricted discretionary was enough, was that clause should state that reverse sensitivity effects that may constrain, limit, or otherwise adversely affect existing or future quarrying operations.
Have you looked at the definition of reverse sensitivity in the HUT plan?
I don't know off the top of my head, no, but I can.
The reason I say it was that 2 hearing streams ago, hearing stream 2, there was quite a lot of discussion about what the definition of reverse sensitivity should be in the context of the HUT. And if you look at the regional policy statement definition, it's relatively concise, whereas the HUT plan definition is much longer, like 1 line compared to half a page difference. I don't possibly need to do it now, and if you're looking at coming back to us with some further information, it might be worthwhile you having a look to see whether that definition or the RPS definition covers the matters which may be concern to Winstones.
Okay, thank you. Okay. So that's that for that section. So then the next matter is cause P7. My view on that is that it should be deleted. There shouldn't be a provision for general protection in the zone. However, if it is to be retained, then it should reflect the planning tool that is in the zone, which is the special amenity area overlay, or the quarry, sorry, I add to the confusion of what they are, quarry amenity protection overlay. And I've given some wording around that as well. And I understand in terms of that amended wording or the tying of that policy to the special amenity area overlay, that would be agreed by Mr. Bellamy. The remaining 2 matters relate to the 2 points that have been somewhat of discussion already in terms of both the height, the maximum height standard for standard 1 and then area 3. Obviously you'll gain full appreciation for those when you're on site. Just in terms of that maximum height, the suggestion in my rebuttal evidence would be amended in terms of that change to reflect that outcome. However, there is the opportunity there to amend the standard to reflect a maximum RL height structure is the clear intent of Winstone Aggregates not to breach the skyline. And Mr. Compton-Mon has given you some evidence there on what that could be. The only addition, and I just remark on it because it hasn't come up, is also to reflect the agreement between Mr. Armstrong and Mr. Compton-Mon and Mr. Bellamy and myself, just that there would also be a clause that say all new buildings and structures must have recessive low reflectivity finishes, excuse me, to reduce contrast with the quarry and vegetated backdrop, except where required for safety or statutory markings. And that clause would go in there as well. If you were to rely on the standard as notified, which would have those 2 parts, that would just drop in as C. Otherwise, it would be amended into there, as I've suggested. With respect to area 3, based on the evidence of Mr. Compton-Mon, I don't consider that the amenity area protection is required, particularly with respect to the visual benefit and when considered against the benefits that have been outlined by Mr. Heffernan for it. If you are of a mind to include a control then as outlined in my evidence, it can be achieved and would fit in with the structure of the PDP to amend the mapping to reflect whatever distance that you felt was appropriate, be it 10 metres or a 20-metre line that would go across there. And that would just amend that area 3 as shown. That would fit with the remaining policies that I suggested be changed and standard. So those are the remaining matters in dispute. I hope to take questions on that or provide comment. I know there's been discussion on the MPS infrastructure. If you have any interest, welcome a comment.
Well, yes, I'm interested in the MPSI and what we can actually do with the MPSI.
Yeah.
In the context that Belmont Quarry exists at the moment, and you're not necessarily looking at anything new, well, you are in terms of your fast track approval process, but the concept of a quarry in the broad location is still there. But any other observations you think might be useful to us would be welcome.
I think it's fair to put to the panel that, you know, just in terms of that general agreement that I have with Mr. Bellamy in terms of the direction of the quarry zone. I mean, I think policy 5 with its direction to provide for infrastructure supporting activities is generally being achieved. And I think you can take some comfort in that. There was discussion about other policies and their relevance. And I mean, I appreciate that through the evidence we refer back to the MPS, just really in respect to where there was the introduction of activities that conflicted with the enabling provisions of quarrying. And that was really it. The other policies, 10, 11, I agree, they don't speak directly to the infrastructure supporting activities. And it's a fun document, the MPS, and it's curious in its attempt to provide for infrastructure and then recognise that there's supporting activities and ancillary activities and then kind of go silent on them other than that policy. But like I say, I think that policy 5 is really the one that you can rely on. And I think in general terms that has been provided for in terms of the quarry zone provisions. And where it hasn't, we've reflected those and I've addressed those in my evidence. And I think for the most part, those matters are all agreed.
So certainly the last suite of national policy statements, the changes to existing and the new ones, were I think from my reading of them, designed to give a deliberate hand up to quarrying, which never existed before.
Agree.
Knowing the challenges of firstly finding and then dealing with the potential range of environmental effects that quarrying does produce. And it's not only in the district context, you've got your regional context as well. So those of you from Auckland have the benefit of having one plan all in one place. So we have, yeah, and I'm sure Belmont has a whole suite of regional consents that it runs under as well, dealing with discharges and discharge to water, discharge to air. Any water takes, those sorts of things are all included under another set of provisions.
That's correct, yes.
Right. Thank you for that. I'll just ask my colleagues whether they've got questions, either in the evidence in chief or from the rebuttal.
Just one. This morning we asked Mr. Bellamy whether were there any operative plan provisions or overlays that would continue to apply to the quarry site as a result of the ministerial exemption, partial exemption. And he's going to come back to that on us, but have you considered that or assessed that, what provisions might continue to apply? Are there any special overlays or landscapes or habitats that may continue to be managed by operative plan provisions?
I have looked into that to an extent that there aren't any that I'm aware of. So Mr. Bellamy spoke to the, or apologies, it might have been, so I spoke to the SNR rules, which are mapped but don't apply to privately owned land. Although part of the mapped SNR does extend up into the regional park, so it applies in the regional park. And then in terms of the site, there's no other mapped overlay. The amenity area that's being considered under the proposed plan as well covers the same area.
Thank you. We've traversed quite a few issues already, and I don't have any further additional questions for you, Mr. Hopkins, but I do thank you for your participation. What we're expecting is that with the minute there will be some questions to you, and to me, yeah, you're probably right. What's still in play? Standard 1 definitely is still in play. Area 3 is definitely still in play, and we want to be able to work towards a solution to those as much as we can, but we feel we probably just haven't got the right evidence on either at the moment, so we will be seeking clarity on that. So thank you for that.
Thank you.
Ms. Tancock, is that all right with you?
Yes, that's absolutely fine, sir. And if there's any other material that the panel thinks would be helpful to make its decision, obviously we can provide that in due course.
Thank you.
And we'll get those notes from Mr. Herbert as well.
Yes, yeah, no, Mr. Herbert's information was useful, so thank you for that.
Apologies, he was sick last week. Just quickly, Commissioner Mas-Pratt, policy 60 is a particular regard to in the RPS. So I think probably where you were getting to was that the MPSI does obviously have stronger directive language to decision makers there.
Well, thank you all. We will adjourn now. We'll see you, Mr. Heffernan, at 9:30 tomorrow morning, and then we'll have a brief discussion and work out the follow-up minute which we require from today's proceedings. So, thank you all for your time. Thank you. We'll do a closing karakia first. Excuse me.
Te uruta ponui, kia wātia, kia mama, tēnā kua, te tinana, te taiwaro I ruka. Kura I rongo, whaka irihi ake ki runga. Kia wātia, aira, kua wātia, hau, haina.